Dear colleagues, dear friends, it's a pleasure to be here and it's a pleasure to welcome you to Szeged as well. As far as I know, I can also welcome people online via YouTube. So welcome everyone on the opening of WIPS 6, which is a wonderful chance to bring back the series to Szeged in person. It's already 3 years that we had the last chance to have WIPS in person here in Szeged. We already had one during the pandemic period. And as you might know, it's a big challenge and big question these days to organize an event in person or online. The last 2-3 years have changed so much in our life. It's actually not an exception what we experience these days. Just due to COVID, we have lost one person for this event who was tested positive 2 days before. Well, it's certainly not thanks to the Ukrainian-Russian war, but we also lost 3 people who are unable to travel because of this conflict nearby. And the biggest problem to me is that we couldn't expect that airplane carriers are not doing their service. They just canceled a few flights yesterday, and so we don't even have the keynote speaker for today here in person. If you do the keynote speech via Zoom, but we also have someone from Finland who was en route in Helsinki when he was told go home rather than come here. It's a pity, but this is what we have to live with. And by the way, we have to focus on what we have. We have to focus on being here and having so many wonderful people coming from so many countries of Europe. So welcome to Szeged. Let's say welcome you back to Szeged, as like Enrico, who is the most senior WIPSer here, and it's always a pleasure to have new faces coming to Szeged. You might know, or maybe not, Szeged is usually called as the city of sunshine, because it's a very sunny and hot city, not necessarily today, but it's good, otherwise it would be 35 and hot, humid weather. We are lucky it's only 25 and hot and humid weather. But anyway, I hope you will enjoy the city as much as you can, and of course the conference as well. I'm not sure how you are doing with this, but one of my favorite authors is Kurt Vonnegut. If I pronounce his name properly, he always complained how his name has to be pronounced. And he had, in his 1973 address at rededication of Wheaton College Library, something which I like a lot, and let me cite it word by word. The burning of the Library of Wheaton would not be the intellectual catastrophe that the burning of the Library of Alexandria, Egypt was. There were no duplicates of many of the books at Alexandria. Our civilization has since developed the mania of duplication. Because there are so many duplicates of everything, our culture can be said to be fireproof. I love this sentence, although totally not related to law, but it's related to something we are at least focusing on today. Cultural preservation is not, by the way, a mania. It's a very important thing for us because cultural heritage, as we see it, especially during pandemic and war times, can disappear quite quickly. But of course, cultural preservation has its own limits to a certain degree, and one of those limits might be related to copyright law. We are at least partially here to address questions related to the cultural heritage, preservation issues, and copyright overlaps. This is something which is organized, co-sponsored, or whatever word we have to use here by 2 organizations or 2 collaborative groups of wonderful people. Recreating Europe is a project funded by the European Union, and that is Szeged a part of. And there is also inDICEs, which took an active role in organizing, putting this event together. I wanted to say welcome inDICEs here as well. We have at least one representative from inDICEs here, but we are expecting a little bit more. But but Recreating Europe is very much present here. I also wanted to highlight one more thing here. Some of you are newcomers to WIPS, some of you are returning people. You have to see that this event, as the name indicates, is dedicated to be a workshop rather than a conference. I wish you the chance to have conversation both in the room and outside of the room, formally, informally, enjoy talking to people, because this friendliness, this friendly environment plus the cities that makes WIPS such a lovely event to organize and of course to take part in. All in all, we might be slightly less than expected, but we are here to enjoy these 1.5 days, and I could only tell you that I enjoyed very much putting together the program, so I'm looking forward to your presentation. And to cite one more thing from Kurt Vonnegut, which is practically a title of a book of him. If this isn't nice, what is? I love this statement from him. So let me wish you all the best for these 1.5 days, and let's officially open the conference here, and also ask our keynote speaker Maurizio, who we hope to be able to see, because we don't see his face on the screen yet, to deliver his keynote here. Maurizio is, by the way, a professor of the University of Torino. He used to work in the United Kingdom, but many of you might know he moved back to Italy. Yes, wonderful, we see you, Maurizio. The floor is yours.
Hi, Peter. Hi, can you hear me?
Yes.
Oh, okay, yes. Let me tell you how much I regret not to be there in person. I was really much looking forward to this opportunity to see you again and to see many friends and colleagues whom I've not been seeing for a long time. And to spend this time with you discussing the issues of copyright IP and the cultural preservation, which are very much at the heart of my own research. So I'm sorry, I will have to speak with you as in the Big Brother from a screen. So I hope what I'm going to tell you is not as scary as in the Orwell novel. I have some slides to share. Can you see it?
Yes.
Okay, let me. Okay, so without further ado, let me start to address the topic of my speech today. The title I chose is Rethinking the Commons in the Age of Data Capitalism. So let me start with some tentative definitions of what is mentioned in my title. So as data capitalism, we perhaps pretty much know what is about, is a form of capitalism which has received lots of attention in the last years and lots of definition. Probably one of the most popular one is the one given by Shoshana Zuboff in her book in 2019, The Age of Surveillance Capitalism. Broadly speaking, I would define data capitalism as a stage of capitalism where value is no longer primarily derived from natural or so-called intellectual resources, like in the informational capitalism we knew before the internet, but is directly extracted from human experience, translated in a computable form. So actually data, it is common to say data is the new oil. Actually data is not oil, it's not a natural resource. Data is our lives, our human interactions and experiences and so on. So, and tentative definition of the commons. Here things becomes a bit more difficult because it is commonly said that it is easier to say what commons is not than what it is. We know for sure that commons is not property. We have also some definitions in some legislation, like in the French Civil Code. Generally speaking, we can say also in the common law world that commons is frequently opposed to enclosures. So is a space which is not property of anyone. So anyone is in principle free to use it. However, it also implies some duties from the side of the community that wishes to take care of the commons. And a point that I want to make in this complex discussion about the commons is that the commons are frequently given for granted, at least until we lose them. And Peter gave a perfect example just a few minutes ago, a public library. Okay, so a public library, we do not even realize how important it is to have public spaces like a library. we realize how important it is when it gets destroyed, for example, by a natural accident like a fire, or when it is privatized and is no longer a commons. So commons are frequently given for granted, and the same, I think, applies to IP law, to the concept of public domain, which is the way in which IP law sort of translates the definition of commons. Public domain as opposed to exclusivity, and to use a famous definition given by Lessig back in 2003, is a lawyer's free zone. So my argument in a nutshell, so spoiler alert, this is what I'm going to tell you today. My argument is that in the age of data capitalism, the classic alternative between public domain and exclusivity is no longer capable of ensuring freedom to use the commons. And importantly, however broadly we define the public domain. Okay, so I'm going to explore a bit this argument and to explain. And no matter how broadly we define the public domain, this alternative is no longer able to ensure that everybody is capable, has the freedom to use the commons, as in the classic definition of the commons. Okay? Hence, the need to rethink the relationship between the IP and the commons. So, and this explains the title of my speech. Okay, so to make this point, I will go briefly through a very short history of IP and capitalism. Okay, so of course an argument that would require a much broader analysis and probably a whole course. Okay, to explore all this. But I have selected 3 milestones in this story for the purpose of today's speech. The 2 are international treaties. The first one is the Berne Convention. I will focus mainly on copyright today, okay? So the Berne Convention 1986. Then the other one is the TRIPS agreement. And the third milestone is not a treaty, is not statutory law, but is case law, is the case of Authors Guild and Google in 2013, the case on Google Books. So, I suggest to divide the history of IP into 3 periods, into 3 ages. Okay, the first age, which is very long, goes from the Berne Convention to the TRIPS agreement. Okay, roughly speaking, is an age where the IP norms were settled as we know them now. Okay? From the point of view of capitalism, this is the setting of legal mechanisms to enable appropriation and distribution of value in relation to so-called immaterial goods like works, inventions, shapes and configurations, design, and so forth, and so on. So you may remember the theory of Karl Polanyi, the great economic historian, who was speaking about fictitious commodities. So commodities that are created by operation of law. Okay, a work is not a commodity per se. It's not something that can be put on the market unless there is a legal mechanism that ensures exclusivity. But not only exclusivity, but an interplay between exclusivity and permitted uses. So this is what copyright law in this case does. So the resulting IP framework of this long period is the notion, which is still part of today's copyright basics, the balance between exclusive rights and freedoms. And by freedoms, I mean everything that is considered public domain. So we have the ID expression dichotomy, the exhaustion doctrine, okay, and on which Peter has written a leading treaty. Exceptions and limitations, more importantly, fair use, and so on. So, in a way, this is a topic that could be explored more deeply. We don't have time now to do this, but this is a way of interpreting law as an institution that moderates power, the power of capitalism. Okay, capitalism would like to exploit indefinitely any resource. Okay, this is a point that Noam Chomsky has made frequently. So the law is there to limit and to regulate the power of the extraction power, of accumulation power of capitalism. And in particular, to focus more on the topic of today's speech, limiting the power of control over common goods. Okay, so this is an age that Chomsky and Waterston, for example, called the age of regulated capitalism. So there are certain limits that capitalism cannot overcome. This in every area of our civil life. Okay, so now today we are focusing only on IT, but of course the argument can be extended to any area of our society. Think of the welfare state and so on. So what happens is the next age, which starts more or less in the 90s, and I use the date of the TRIPS agreement because it's a milestone in this story. Is a story where the relationship between IP and capitalism changes significantly. So here we are in the age that some economic historians call the neoliberalism, okay, and unregulated capitalism. So to summarize this story, we can say that here we start a process of plunder of the commons via IP expansionism. Okay, this is something on which IP scholars have written and expanded a lot, so I'm not going to review all this literature here. Expansion in terms of subject matter, new subject matter like computer programs, databases, and so on, scope, duration, and global reach. Okay, the TRIPS agreement are an expansion of IP to other countries, imposing, for example, mandatory patents for pharmaceutical products and so on. And the dominating narrative, at least at legislative level and at least in some part of the world, in the US and the EU, is the ideology of capitalist private property, which permeates all the EU copyright harmonization process. To summarize this process, we can use the words of Goldstein in his 2003 book, Copyright's Highway. Extension of private property into every corner in which people derive enjoyment and value from literary and artistic work. So this is the dominating ideology at legislative level, which is reflected in the rhetoric of high level of protection in EU law that we find in the InfoSoc Directive, in the Enforcement Directive, and in many decisions of the European Court. Okay, so I'm not going to spend more time on this. I'm just want to focus on the reaction to this dominating narrative and the creation of a counter-narrative that has dominated and still is dominating academia. I mean, when I started studying copyright and IP law many years ago, I have to say this was the dominating narrative in academia. Public domain, exceptions and limitations, what Boyle called new environmentalism. Okay, so to react to this plunder of commons operated via IP expansions. So I'm telling things that many of you know already, because this is the bread and butter of IP education in academia in US and in Europe. Okay, so now coming to the new part of the story. So 2003 and 13, I argue that the Google Books cases are a turning point in copyright law. Briefly, in what we have seen in the Google Books cases is that fair use, which as we saw in the classic structure of IP, is meant to be a limit to the power of control over information on goods. In this case, we have seen clearly that fair use leads to market monopoly over secondary uses of copyrighted works. So uses enabled by information technology, by artificial intelligence and machine learning and so on. So we give details of this process in a book we published in 2013, but just to be very brief, the Google Books in public domain are still in public domain. Everyone can access them and download them. However, only Google has the power to do automated processing and to do artificial intelligence, machine learning on these books. So there is a de facto monopoly over secondary uses, which is enabled by fair use. Okay, so is the exception that gives the legal basis to enjoy a complete monopoly over secondary uses. So and this is a paradox. Okay, stronger fair use leading to more, not less enclosures. So this, why is this the case? Well, the case is because the new data capitalism has changed the way in which capitalism extracts value and accumulates and controls value from immaterial goods. And this is a phenomenon that is not only limited to copyright, but it applies to all intellectual property rights. So there is one characteristic of this new capitalism is that is relying less and less on patents and other IP rights and more on trade secrets. So if you compare, of course, Google and Amazon and the other big players, they have huge patent portfolios. But if you compare the patent portfolio of these huge companies in comparison with the patent portfolio of big companies in the classic manufacturing capitalism, is much less, to the extent that is 1 to 10 the proportion. Okay, this is a phenomenon that now is being studied extensively by economists and by lawyers. So what is replacing IP law? So the fact that this capitalism is no longer based on fictitious commodities created by IP law is the emergence of what we call the de facto powers. Okay, so the de facto power of control over informational resources, over data and other know-how and other informational resources. This obviously challenges the conventional IP wisdom, because we can see that weaker IP favors large and highly integrated industries, with a notable exception of the pharmaceutical industry, which still relies heavily on patents. And this favors small guys today. This is not a new phenomenon. This occurred also in the classic capitalism. The difference is that now IT-intensive companies like Google, Amazon, and Microsoft, and so on, Apple, they are they are they more and more relying on de facto powers and less on IP. So this leads to the point of my speech. I mean, the argument I would like to submit to your attention. So the need to rethinking the commons. So if in a world where big companies that now are more powerful than states, okay, and hence they influence IP policy. So think, for example, the way in which big tech companies like Google have lobbied for, are lobbying for adopting fair use in other jurisdictions than the US. They have lobbied on stronger exceptions, for example, during the UK copyright reform a few years ago. They have been very happy about, for example, the expansion of certain permitted uses like parody. Okay, so parody, everybody likes parody because it's the right of the users. But YouTube is profiting hugely from a broad definition of parody, and so in this situation where big tech companies that are powerful than state are able to influence legislation and to determine the trends in legislation and in jurisprudence, so where is the room for regulation through IP law? So the question is ex-ante regulation deemed to fail? Well, ex-ante regulation is the typical way in which IP regulates relationship of power. Okay, so the balance of between, as we said, between exclusivity and permitted uses, exclusivity and freedom. So there are other areas where ex-ante regulation apparently is more efficient than IP. For example, the fact of imposing transparency obligations on algorithms that now we see in the Digital Services Act. And then we have ex post regulation, competition law, antitrust. Okay, and we are witnessing the emergence of a new paradigm in competition law. And here I mentioned also some of the scholars that have given important contributions in this respect. So a new paradigm in competition law, for example, the doctrine of essential facility now is being applied to algorithmic powers and so on. So little by little, and the dominating paradigm in competition law, which has been dominated by neoliberal economics, is starting to change. And how about IP law? So we have seen that are we still insisting on the distinction between exclusivity and permitted uses? Are we still thinking that expanding permitted uses is a good thing because it favors pluralism, it favors competition? So we have seen that this is no longer the case. So it is possible that also IP law should go through a change of paradigm. So my argument is that the Google Books cases, and which is not isolated cases, okay, there are other cases that confirm this changing paradigm, requires a change of attitude in copyright scholarship and in IP scholarship in general. Okay, the argument is perhaps more complex in patent law, but it still follows the same itinerary, the same line. So the emergence of de facto powers that make ex-ante regulation shaky. So, I give just a couple of hints of how this change of paradigm might look like. So, one is the impositions of rules of reciprocity on every use permitted by exception. These uses cannot be appropriated if they are made by virtue of a copyright exception. In general, I think that there should be a shift beyond the paradigm of exclusivity versus exception. So I've said this already. And what is going to replace this paradigm? Well, possibly an approach that is no longer opposing exclusivity, property rights, and permitted uses. But the question is the strong versus the weak. Okay, so to protect the weak part against the excess of power of the strong part. And if you think of copyright as always been in its classic vision, its classic form, has always been a rule of law to protect the weak against the powerful, against the excess of the power. So the Statute of Anne, as you may know from copyright history, was introduced to limit the power of the London publishers, of the London booksellers. And along the history of copyright and intellectual property in general, we see this operation of law as a law that tries to limit the power of capitalism to appropriate and accumulate. Okay, so we have given some examples before. So I think this could be the new approach that guides legislation and the judiciary in the new data capitalism, okay, which is dominated by de facto powers. Okay, so this concludes my speech. I don't know if we will have time for some questions and discussions. So, as I said, I would have very much liked to be there in presence to discuss this and the other things that will be addressed at the conference. But thank you very much for your attention.
Thank you, Maurizio. And I just exchanged an email yesterday with another Recreating Europe team member, Jo Pedro Quintais, and we totally agreed that it's the perfect time to be an IP scholar. We have so many challenges, overlaps with other fields, including DSA, etc., that I very much enjoyed this thought-provoking introduction to the conference. Now we continue. Maurizio, yes, there will be time for Q&A. I would recommend to listen to the 3 other presenters or 3 other presentations, and then we will have time for the Q&A. So please stay with us by Zoom, and we will most probably raise questions to you as well. So the next speaker will be Camille Francois. Just a second, which is your presentation here? Oh, come on. Okay, that's it. Cool. Sorry, I didn't see you. Okay, the floor is yours.
Thanks. So, hello everyone. I'm Camille Françoise. I am a Creative Commons Open Culture Grant Manager. So, I'm taking this. Putting my notes. Perfect. So, as you probably know, CC is the world's leading non-profit organization that stewards the CC licenses and tools and that drives copyright reforms to support better sharing of copyright content in the public interest and in tune with the sharing possibilities unlocked in the digital environment. CC licenses are meant to lower the barriers to sharing of work protected by copyright. Yes, perfect. But the thing is, our licenses can only do so much. They are a patch and not a fix, and cannot address all the barriers to better sharing of grams raised by a copyright system that is often complex, unbalanced, or outdated. If we don't act to reform copyrights, this risks undermining grams' public interest, activities in the digital environment, exacerbating inequalities by curtailing efforts to provide universal access to knowledge and culture, and carving a black hole in the world's digital cultural heritage. In February 2022, Creative Commons launched its GRAM policy paper named Towards Better Sharing of Cultural Heritage, an agenda for copyright reform, as part of our Open Culture program. The aim and outline of this policy paper is to provide a key pillar and a reference document for Creative Commons advocacy work in copyright reform in the cultural heritage context, with a specific focus on digital environment. Our goal is to support Creative Commons copyright and GRAM communities, as well as GRAM institutions in their own advocacy efforts and legislative processes. Because CC promotes open culture, a positive global policy framework that fosters GRAM's public interest mission. Why? Because we are convinced that GRAMs play a fundamental role in society. They support education, research, creativity, innovation, and of course the advancement of knowledge. They are gateways through which the public can enjoy universal, inclusive, equitable access to the full diversity of cultural resources and experiences. And of course, they also keep a reliable record of our heritage and preserve our collective memory for future generations. By making their collection available to the public, disseminating information, and serving as public forum to hold society-wide debates, they empower people to participate in civic life and build a sustainable future for all. And yet, copyright law as it exists today stands in the way of GRAMs achieving their mission in the digital environment and establishing a sustainable, equitable, and meaningful digital presence. That's the reason why we need to ensure a global copyright policy framework conducive to GRAM's mission. A robust and thriving public domain, a reasonable term of protection, and of course to understand the complex interplay of copyright with traditional cultural expression, indigenous cultural heritage and restitution, and to explore the opportunities and challenges that have been raised and still raised by artificial intelligence. So here is a laundry list of the type of activities that GRAMs and their users should be able to undertake lawfully. We basically need to ensure their needs are treated on equal footing with those of copyright right holders in a fair and balanced manner. So here, for exception for and limitation for GRAMs as direct beneficiaries, it includes to reproduce works for preservation purposes, display and exhibit works, including digitally, reproduce and provide access to orphan works and out-of-commerce works, and born digital e-books, e-works, and digitized works. For users and members as direct beneficiaries, it includes access and use works for educational and private purposes, as research and private study, perform text and data mining, exercise freedom of panorama, use of works in the context of public speech, news reporting, but also for quotation, criticism, review, parody, caricature, pastiche. Of course, to provide access to works in accessible format for people with disabilities, and to make transformative uses as such as to remix and provide other forms of user-generated content. In the policy paper, we also find additional information related to the fact that we are also mentioning not to not have contract override, no override by technological protection measures, and of course to ensure that those exceptions and limitations are have a cross-border application. Some key other items that you will also find in this policy paper is the fact that we need to protect the public domain from additional copyright layer, because digitized public domain work must remain in the public domain. The law must make it clear that there can be no copyright protection for digital reproduction of public domain works. We believe it's crucial that copyright law in every jurisdiction, as well as behavioral norms and contractual agreements regarding the digitization of GLAMS collection, clearly prohibits anyone from claiming copyright or related rights over faithful digital reproduction of public domain works. The second item is related to the reasonable term of protection we would like to see, because excessively long copyright terms negatively impact GLAM institutions as they thwart efforts to increase access to knowledge. We've seen that empirical work has shown that culturally important books are less available in countries with longer term than shorter ones. And therefore, we believe that copyright should support a robust and universally accessible public domain and not unduly delay works entry in the public domain. You will also find in this policy document some position on the legal and ethical issues related to traditional cultural expressions, because it's also important to note that GLAMs have a range of responsibilities and duties in respect to indigenous cultural heritage, in particularly in light of questions around restitution and repatriation, and of the sensitivity around heritage linked to communities. And the last point would be on artificial intelligence and cultural heritage, because I think you're also aware that developments in AI present exciting opportunities for GLAMs, but also raise copyright questions. For example, regarding the use of GLAMs collection for AI training, the copyright public domain status of AI-generated content, and how the open ecosystem should address barriers beyond copyright to opening up and sharing the GLAM collection. So we are actually, based on this GLAM policy paper, we are now developing a guide for policy makers. So you will find plenty of information here. So the goal of this guide actually is to offer key concepts, top policy issues, a summary of top policy issues, some recommendations, some case studies. We are working together with our community on that guide, and so that's also the reason why that if you actually you are interested into joining us and contributing to that guide, we would love to have you there. The next call is on the 30th of June, and I'm happy to discuss detail if you're interested to engage on those questions. And we invite you all to join the platform that we have within Creative Commons, because we are a community as well, and we are working with the Creative Commons Open GLAM platform and the copyright platform, and so you're very welcome to join the conversation and engage with other IP experts and activists on this topic. And I thank you for your attention.
Thank you for this presentation. Our next speakers, this time truly speakers, is going to be the greatest group of representatives of Recreating here, because in Recreating Europe we have various work packages, and one of the work packages, work package 5, is focusing directly on the GLAM sector. And we have a wonderful team of collaborators here coming from Trento and Pisa at the same time. I would like to. Do you have a presentation?
I do.
Okay.
There
you go. That's right.
Oh, but Martha, is this the last one?
Yes, that's the last one.
Great.
I just saved the last one. And so let's see what our colleagues in Recreate, I hope the camera can show them properly, because I'm not sure. So the floor is yours, ladies, and tell us what your research found in this project. Sorry, give the microphone.
Okay. Sorry, I'm having trouble sitting in here because I'm short, so it's not that easy. Okay. No, no problem. All right, so we have 15 minutes in total, which is really a challenge. We'll be quick as we can, but keep an eye on the time for you. Okay. All right. So we are here today to present a research that we have been conducting within Recreating Europe, one of the organizing projects of this event, within two main working packages. Working package 2 on user rights, and working package 5 that focuses on GLAM, on cultural heritage institutions. This research of ours has been quite interesting, but again challenging, because we are trying to mix our different approach. In Recreating Europe, we really believe that we should play and put a lot of attention on our stakeholders that are, as I said, GLAMs and user rights, and we value their contribution to our research. They provide us with very important and insightful data that we believe should always support any proposal for copyright reform and IP in general. Our outline is this, okay. Yeah, I think I should stay here, so it's just easier. Okay, so that is our, this is our outline. So we will provide very briefly, as we're running out of time, some context about this project of ours and on our respective working packages. We will give you just a very brief outline on the subject of our research and on the framework, indeed, of our research. And then we'll focus on these two stakeholders that I mentioned, so cultural heritage institutions and user, providing two main examples, so two exemplary issues where we see their interaction working well, but sometimes colliding, conflicting, which are freedom of panorama and reproduction of works of visual arts in the public domain. And we'll conclude with some remarks on what are the next steps of our research. So the project isn't working?
I think the slides aren't moving.
I mean, I can see it from here, but not on the main.
Yeah. Interesting. It's not
Maybe
working.
this one.
It's working.
Okay, it's working again now. Okay, so the project. The project, I think that what is important to highlight here is that it is it really has a strong interdisciplinary approach, in a sense that we have colleagues, experts with very different expertise, and this is something that help us have and embrace really in full a participatory research strategy, the strategy I was mentioning about having insightful data to provide along with our research. And what we really value, as I said at the very beginning, is the work we do with our stakeholders. we map, we verify, we explore, we guide, and we want to do in contribution with the stakeholders that we represent. I will skip this slide just because I really hope that you will be curious enough to check our website, to probably go on Zenodo, because we have a community there where we upload all of our deliverables and all our research output. But also I would encourage you to come to us and discuss the things we are doing, and perhaps explain what are your thoughts about what we are doing, especially if you have different views. That would be very, very helpful for us. So skipping this, this is the main framework of our research. So that's very dense, I know, but I promise you that I will try to explain it more clearly. So we focus on the relationship between cultural heritage and copyright. And we believe this is a very special relationship. It's a unique one, one of a kind, because they are interrelated, especially in the context of a GLAM. They work well together, but sometimes they collide, they clash. And this is a problem, especially when they go into different directions. This, of course, is natural because from a strictly legal perspective, they have different approaches. So the provisions in cultural heritage law and in copyrights are different because they have different approach intrinsically, in a sense that in cultural heritage law, you will see how the public interest prevail, or ideally, this is the idea of a cultural heritage law should prevail, while in copyright, as we also have just seen from the other speakers, it is the private interest dimension that usually prevail. So I'm not saying that they do not relate and they do not influence each other, but it's important to keep in mind that they essentially have the very different approach to this extent. And we also want to depart from a concept that we believe it's the connection point, so the link between these two words, which is the right to access culture. We are aware that this concept is very critical. It's difficult to manage, also to be explained, has a lot of nuances that are difficult to really tell in specific and detailed terms, but we assume this concept to be the one that is framed by international law, and in particular we refer to Article 27 of the Human Rights Declaration, Universal Declaration, and Article 15 of the International Covenant on Economic, Social and cultural rights. So this is where we depart from. And we believe that this interest, this right to culture is essential for cultural heritage institutions, but also for users. We think that this is the starting point, and this is a crucial element of the digital public mission of our stakeholders. But this mission is really at stake, has some difficulty to be performed when we see cultural heritage provision and copyright provisions colliding. So going back to what I was saying at the very beginning. And this, for instance, happen when or applies to a limited extent, for instance, through the flexibilities we heard about, but cultural heritage provision applied, and perhaps bring more barriers to this framework. So makes the attempt to open culture, to give access to a culture, very difficult to be done in practice. And this is something that we should not forget, and we should all explain how it happens. We'll provide two exemplary issues to this extent, so my colleague will focus particularly on the two examples that I just told you about. So I will give them the floor now. Pelin first. Just to mention that Katerina Zganga and Magali Contardi are not here today, but they are definitely part of these conversations, so we say hello to them as well.
Then I will stay here. Can you all hear me clearly? Okay, perfect. I promise to be quick and wrap up my part in 5 minutes. Okay, so following up with Julia's presentation, first of all, I would like to provide some information about what do we mean when we're referring to copyright flexibilities within the Recreating Europe context. Because when we're talking about copyright flexibilities, we're not just focusing on just exceptions and limitations, but we're also focusing on a broader spectrum of flexibilities that would enable end users access to culture and use cultural content. And these also include public regulatory sources as well as private regulatory sources. When it comes to public regulatory sources, of course, we're referring to exceptions and limitations, but in addition to that, we also include certain other elements, such as the termination of copyright or copyright exhaustion, as well as the public domain. And when it comes to private regulatory sources, it is mostly our colleagues, Professor Meze and Dr. Harkai, who are working on this. And they're also trying to understand how online content sharing platforms are also enabling end users access to cultural elements, and how these systems, the end user license agreements or other contractual provisions, are helping end users to access and use cultural content. But today's presentation will be focusing on merely on the public domain and then freedom of panorama. And it will be my part to deal with the freedom of panorama. And here, I would like to start with providing you with a brief, let's say, description about the freedom of panorama exception. We all know that this exception was introduced to the EU copyright acquis in 2001 with the InfoSoc directive. And it is providing, or it is requiring states, though being an optional exception, to introduce either exceptions or limitations to right to reproduction, right to communication to the public, as well as making available to the public for the sake of enabling these beneficiaries to reproduce and to use these works or other subject matter that is made to be permanently located in public spaces. So as you can see, this is a very broadly articulated, a very broadly formulated copyright exception or limitation. And plus, we should perhaps once more highlight that this is an optional one, which gives a margin of discretion to states whether or not to implement this, and also, again, a margin of discretion to formulate this exception in accordance with their own needs and expectations in their own national laws. And this is an important issue because once we take a look at this table, having mapped these flexibilities and especially the freedom of panorama in the EU member states, we have realized that even before the InfoSoc directive, 14 member states have already had certain copyright regulations that are addressed to this purpose. Here we have highlighted Greece because there are certain controversies about the Greek freedom of panorama exception, because it is quite narrow in the terms of its scope of beneficiaries, as it is only addressed to the mass media. But when it comes to the post-InfoSoc directive process or the era, we also realized that certain countries decided to amend their existing laws to bring their laws in line with the EU standards, whereas some others have introduced this exception for the very first time to their national laws. And there exists only one country which has not implemented this optional exception, and in the Italian legal landscape we cannot see anything similar to this freedom of panorama exception. But another issue is that given the broad articulation of this exception, we also realized that certain countries had different approaches to beneficiaries, as in the case of Greece, or more or less most of the countries adopted the same scope of permitted uses, but there are times that we also see certain limitations or restrictions on the interpretation of public spaces. If I'm not mistaken, Hungary is having a differentiation between indoors and outdoors public spaces, whereas in some other countries we also see that there are restrictions imposed upon the means of use or the means of making available or reproducing such kind of cultural content. So this brings me to my other slide. We're planning to turn this presentation into a paper, and for the sake of our paper, we want to focus on certain countries. So we have chosen 5 countries, including Italy, but given that there are no provisions in Italy, here you only see a quick glance of the legal landscape of these 4 other countries. Well, very briefly, we can say that even a very quick glance at this table shows the points that have been harmonized and the points that still need to be harmonized, or perhaps to catch up with the digital era and the digital, the digital agenda of the European Union as well. Here, as you can see, more or less all these 4 countries adopted the same approach in terms of defining their beneficiaries, whereas subject matter is again more or less the same. However, the permitted acts can vary to a certain extent, especially in the case of Finland. What we see is that this communication to the public can only be made if it is related to a text that is existing in a newspaper or a periodical. So which gives the impression that this is perhaps something closer to the press review or reporting current events. When it comes to other restrictions, we also see that these are the restrictions that doesn't exist in the original freedom of expression, freedom of panorama exception within the InfoSoc directive. However, we also realize that certain other countries are imposing some other issues. For instance, Ireland is mostly about reproducing these cultural content by analog means, and when it comes to the digital means, they're only allowing taking a photograph or filming. Or again, in Finland, we can see that we can also see that the reproduced material cannot be the main motive, cannot be the main theme of the copy, whereas there should be some other elements, again, and this is an imposition on the use of this right. And again, in Austria, we also see that there are some other elements of restrictions where we can see that, for instance, the reproduced materials cannot be located in public spaces. And this is the point that I will leave floor to Marta, who will be continuing the presentation with the public domain.
Thank you very much. Okay, I'm talking about Article 14. The reason is, again, we are taking this double perspective, as also the presentation of Dr. Francois highlighted. We are also looking at exceptions and limitations, or more in general, copyright flexibilities, targeting cultural institutions and end users. So these two subjects. And when it comes to Article 14, it's also interesting to understand which is the target of this disposition. It may be useful to remember that its origins could be linked to Article 6 of the new directive, new copyright directive, which is about preservation. So it relates to cultural institutions in a way. But the overall result is a disposition that is also is about cultural institutions, but about end users as well. And the interesting thing is that it's really difficult to understand whether this is an exception or limitation. Also depends on whether we are, sides of this debate we are looking at. But it's a flexibility because it regards public domain, which is something where copyright shouldn't exist. By the way, it's a free lawyer zone, as Maurizio Borghi was remembering from Lessing's work. So it's definitely something that it's interesting to look at because it now is part, for the first time, of our copyright framework. Just a few words on the article, although I believe that the context which allows us to understand is really well explained by Recital 53. We're talking about something that relates to the digital environment, something that relates to the circulation of in a cross-border dimension, so the internet. And we're talking also about faithful reproductions and the field of visual arts, which limits, in a way, its scope. I believe that overall, this introduction should be welcomed as a positive addition to the copyright framework, because it introduces some legal certainty in a field where there is not much. And moving on at a closer look, we understand that this legal certainty is really well defined in relation to a particular subject, that is photographs. The reason is that, Article 14 now says that these reproductions of public domain works would not be object of copyright or related rights. And the first example that comes to mind is that today non-original photographs are protected by, could be protected within the EU copyright law. The reason is that there's Article 6 of the term directive that allows for protection of non-original photographs by neighboring rights. So some member states have this type of protection. And again, looking at the works of visual arts as the main subject of the article, we see that there is an open catalog here. So if on one hand we are able to understand that the scope would be easy to understand and specific, the fact that works of visual art are not defined doesn't help us to understand which type of reproductions will be targeted by the norm. And a couple of references to the Berne Convention that doesn't really as works of visual arts in its attachment, but again leaves the catalog open. And finally, the last element of this conundrum is that, of course, this rule would be valid, but when the work is original, when the material resulting from the reproduction is original. I understand I have to be very quick here, so just in a nod to Pelin's work before, here you see some examples of that we are targeting. So these are preliminary results of this analysis we are taking on. We see 2/3 main strategies because Ireland doesn't have the protection of non-original photographs we were mentioning. So what we see now for Article 14 is basically that either countries that protect non-original photographs have introduced and modified, amending their own provision on non-original photographs, or, as the example of Italy and Germany, prefer to introduce a general norm with a transversal scope, which is probably the best way if you want to target, if we are trying to target the enhanced access of cultural heritage, which is the focus of our but just let me finish on this, because Italy, unfortunately, opens the Pandora's box in saying that, the Article 14 would be a rule, but cultural laws on cultural heritage would still apply. And this is a powerful example because these laws, Italian laws, bring in the idea of limiting the access to cultural heritage, unfortunately, because they impose in some cases, not in all cases, but especially for commercial purposes, the fact that an authorization and sometimes fees would be needed. So, very briefly, to conclude on our research trajectories, but maybe this could be discussed further in the Q&A as well. We see we see the fact that there are other limits other than copyright law as a very, very important element. We are talking about laws on cultural heritage, but when we're talking about accessing cultural heritage, there are other limits that come to mind. Protection of personal data, for instance, ethics. And again, this traces back to the debate that Julia was illustrating, right to culture versus copyright. This brings to reflect on copyright rationale. And finally, just to conclude, with exploring the room of reform of copyright law, we believe that, the EU competencies are a point to discuss. And now we see cultural heritage is also being framed within the data strategy. So if cultural heritage becomes data as well, it's really important to think this object change, and it changes the way we have to think about the normative framework on cultural heritage. And this is really visible in the recent recommendation of November 2021 on the European Common Data Space for cultural heritage. Sorry I took too much time, and thank you very much for your attention.
I would say that was an excellent introduction to the fact how complicated research we do in countries, and we could probably sit here for hours to hear on the experiences of all the other countries. But we should go on, and please, let's have your humor stick. There you go. Okay. Second complete?
Yeah, exactly.
Okay. And now again we are going to hear a co-authored presentation from or by Cristiana Sappa and Enrico Bonadio, and as you see, Cristiana will start. Please.
Okay. Thank you very much, Peter. Good morning, everyone. I'm very happy to share with you some very quick talk, a very quick thought on the challenges and opportunities related to the digitizations for GLAMs, and I will principally focus on GLAMs and in particular on museums, while Enrico will go beyond that. Thanks, by the way, to Peter for this wonderful organization of this very nice event. Now, the first very short remark is that we used to refer to GLAMs which is an acronym that is basically putting the focus on the fact that we are having a sectorial approach on the cultural heritage. But we shifted from GLAMs to cultural heritage institutions, which is suggesting a more holistic, a more comprehensive approach of the research to be done. Of course, I understand that the different sectors, libraries, museums and archives are generally studied in a more sectorial perspective, but at some point we should be probably more synthetic and less analytical for several reasons. And of course I understand the peculiarity of each of them. Now, what our cultural heritage institutions do? Like Camille Françoise was saying in the Wikimedia page, the reference is access, they enable the access to knowledge. But there's a discrepancy between what Wikimedia says and the acts on copyright, and in particular on cultural heritage says, like Julia Dora was also referring. In the Cultural Heritage Acts and Codes, we generally refer to preservation a lot, but preservation is not a mission, a final aim per se. Preservation is functional to what? To education. And this is why I generally refer to the educational mission of cultural heritage institutions much more than the digital missions, because the digital infrastructure is a tool to enable the reaching of a broader target. Now, how do GLAMs, how do cultural heritage institutes, enable the educational missions? By enabling the access to their premises. Basically, we are able to go there to enjoy the exhibits or to access the literary works and so on and so forth. And actually, as for that, there's not a big challenge nor a, not a surprising opportunity. Along the years, the lawmakers has basically introduced some rules in order to facilitate also the access to digitized works within the institution. So here we broaden a little bit the opportunities, we killed the limited challenges, and as of today, I would say that the challenges are really marginal in this era. But what is the problem is the second part, where we are talking about access to culture or access to information on cultural heritage remotely. Here we have challenges that have been the same for ages, and the challenges are related to the property-based or control-based paradigm of copyright, but also of some countries like Italy that comes from cultural heritage rules, where we basically need to have the ownership of the rights. And if there's no ownership, what are the keys, what are the steps? Either right clearance, prohibitive, or exceptions and limitations, very often too narrow, or efficient collective management organizations, which is not always present at a state level. What are the opportunities? There are two sets of opportunities: economic opportunities, market-oriented opportunities, and non-economic opportunities. Now, this is my personal point, which is GLAMs, and here I'm cultural heritage institutions, and I here refer particularly to museums, have to focus on educational missions and have to focus on non-money oriented opportunities. There was a tremendous work along the years for, trying to make it happen, the remote access, so the dynamic access, not the static access to original copies in the cultural heritage premises, but the dynamic access, the access to information on that material. And this was possible thanks to institutional initiatives from museums, but also then at the later stage of projects like Europeana. There was a terrific works of communities, and in particular Wikimedia, but also with the help of Creative Commons or Communia, that really pushed a lot for having more and more material out for dissemination purposes, for education purposes, and not only for preservation purposes. Individuals that are acting right now on the different social networks are really much helping that, even if it's not in an orchestrated way. And all this pushed the lawmakers to have regulatory initiatives, so to introduce something within the copyright system like Article 14, that is seeing a lot of resistance from every side, but at least it's there. And also, you know, something beyond the copyright framework. And I'm thinking in particular to Open Data Directive of 2019, where it's interesting to see the evolution of the role of cultural institutions as for data in that framework. And also, all these push the private subjects, the market operators, to be compliant with the fact of having stuff online that is no longer protected. Or they don't actually, they can no longer claim some right on the faithful reproductions on some digitized copy. Now, I conclude very quickly before Enrico takes over on the money-oriented opportunities. They are there. They are very attractive, in particular for museums. I would recommend museums to stay away from that. There was a huge market for digital collections developers already in the very last phase of the analog era, and now it's the very momentum of NFTs that we are going to discuss a little bit later. This is very interesting, but in particular for private sectors. And my opinion is really that the museums stay focused on the educational missions and do not become too much market-oriented. But Enrico will tell you about who can be market-oriented.
Thanks, Christiana, and let me thank Peter and all the organizers to be here again. I was here for the very first edition of the workshop, and it's always a pleasure to come back to Szeged. And yes, just to tell you that Christiana and I have looked at GLAMS in a collective book, a native book that we are finalizing in these months, and where with our contributors, our colleagues, we have looked at not only GLAMS but also beyond. So what we have done, we have looked at both creators, and this is the book, in the best libraries from September 2022, and we have looked at both creators and managers of literary and artistic work. So of course GLAMS is big part of the book, so museums that, you know, with the great chapter by Christiana. We have looked at galleries, Simon Stokes at galleries, Max Marzetti at libraries, and several other intermediaries, universities, and so on and so forth. So let me just, you know, tell something about, for example, galleries, because, you know, galleries massively use digitalized works, right? Artistic works. So where art market professionals like galleries, they sell works of art, you know, they advertise, for example, their artworks there. I mean, back in the days, the way they did it is to, you know, to distribute printed sale catalogs, right? That was before the boom, the internet boom of the late 90s. So much advertising at that time was done physically, traditional. Now it is done online via their website, including online viewing rooms, right? Platforms, social media platforms, Instagrams. If you look, these galleries nowadays, they have their social media platforms, and they, you know, they show their artworks. So when they advertise the work, the canvases, the prints, a number of acts that potentially may infringe the artist's copyright may occur. For example, a high-quality photograph of the work, or possibly a video as well, will need to be taken, and this typically is in digital form, right? And this is a reproduction of the work, clearly, right? So, and such reproduction is likely to be included in the printed catalog, which is then distributed prior to the sale or auction. And this again engages both the reproduction and the distribution rights. So you need to clear such rights before doing that. Also, this takes place also digitally, as we have seen, through an electronic sale catalog or PDF. If this takes place via email distribution rather than online, then this is analogous to the previous one, the B, the reproduction right and the distribution right. And the reproduction of the artwork can be made available to the public online. That's what galleries do. through the website, via social media, online viewing rooms. Again, this engages both reproduction right and the communication to the public right. So they need to clear these rights. I mean, galleries, they do. They have lawyers, and it's quite, this clearance of rights is quite, might be cumbersome. So this is galleries. What about libraries? We know that the Digital Single Market Directive addresses some of the needs of these libraries, as you know, Max Mazzetti in the chapter in our book has analyzed. We know that Article 3 has established the mandatory text and data mining exception, which is quite limited, as we all know. And also we know that Article 6 of the directive allows cultural heritage institutions, such as libraries, to make copies of any works that are part of their permanent collections in any format or medium for preservation purposes. So this is, again, a provision which may benefit, right, libraries. We also know that the Digital Single Market Directive has introduced an exception for mass digitization of out-of-commerce work, and this exception, however, works subsidiarily. That means that it is available if no collective management organization sufficiently represents rights holders for the type of works and the license subject rights. So, in other words, this solution kicks in if there is no market solution such as a license. In the US, the DMCA, as we all know, of 1998, made illegal circumvention of technology protection measures illegal, right? And we know that then also in Europe we have adopted similar provision with the InfoSoc directive. In the DMCA, however, it is also included an exception which allows the Librarian of Congress, after, I quote from the provision, after a complex rule-making procedure and a series of consultations with other institutions, to declare some classes of uses exempt from such prohibition against the circumvention of technology protection measures for 3 years. And such exemptions are granted in situations in which TPMs may have, a negative effect on non-infringing use. We know that this is a big problem with TPMs. Now they might reach over and affect non-infringing uses. So basically, due to these provisions, libraries in the US are exempted from the general rule against circumvention of TPMs. Therefore, for example, libraries may legally remove TPMs for the lawful preservation of software, or video games, no longer reasonably available in commercial marketplace. Okay, so as I said, in our book we have, with our wonderful contributors, we have looked at this. I personally wrote a chapter on publishers, and of course the digital element in this chapter is quite relevant. I, for example, focused on a relatively recent case in India in 2016, where several publishers, OUP and several big publishers, took action against a photocopying shop within the University of Delhi. So they sued both the photocopy and the University of Delhi because they were creating course packs, right? Photocopying books and stuff. There was a massive protest, also by academics, Indian academics, also those academics whose work were published by the publishers which would take action. And they said basically, no, we are not responsible for that. We don't endorse such legal action. We side with students. We side with the photocopy machine shop, the shop in because we really support the right to education. We think that making course packs is important, especially in a country like India, where access to education is quite important and is less clear is less easy than in other countries. The Court of Delhi sided with the shop, with the university, by declaring that copyright is not a divine right, an absolute right. and therefore we need to allow these free users also copying the publishers. However, they didn't stop to lobby, because now, as far as I understand, they are strongly lobbying the Indian government in order to, depart from this case law and introduce legal provisions which would be contrary to what the Court of Delhi said in 2016, let's say. It's an important case. It's an important case which gives us an idea of how negative it could be an overprotection of copyright, especially in those countries where, we know how much these books cost, right? We need to finish. Okay, we have just presented some works, some aspects of what we have looked at with our contributors in this book. Of course, the digitalization elements in this book is quite relevant. So the last slide is this. Costs. Can I say costs? No.
Cost means dust, but cost is...
Okay, okay. Thank you so much.
Just take my keys.
Questions later, right?
No, actually, we start questions. Yeah. But actually, Enrico, your pronunciation in Hungarian is as good as my child's pronunciation. She cannot pronounce these accents, actually. So she would also say kos, which is, by the way, dust in Hungarian language. But kos means thanks. But thank you very much for making this presentation here. We are generally in time, which is good. So we have 10 to 15 minutes time for Q&A. I already see Julia has a question, probably to Enrico. So yes, she really seems to recommend that you sit there.
Was escaping.
Yeah, please. But of course, any speaker can come here.
Thank you for your chairs. Yes.
We can hear.
Online. But online they can hear you.
I think online we don't mind.
Yeah,
It's a little low.
Yeah.
So thank you for your presentation. I wanted to ask you what is the definition that you have of galleries exactly? Because in Recreating Europe we always had this trouble of defining galleries, and we would love to hear your thoughts about how you would define gallery, whether you see them as a private entities rather than public, and so you distinguish them from museums.
Yeah, of course.
I think that it is the notion of gallery can be the two ways. If we refer to private galleries, and Enrico was presenting the chapter on private galleries, we are talking about private market operators that are closely connected to the artistic sectors, and they're somehow in between auctions and then museums. But then we have in the GLAMS acronym, it's galleries and museums, because museums is a very broad notion. When we think about museum, you're from Trento, and there's an extraordinary museums of science in Trento. So there's no artistic work. The issues related to copyright might be there because the museum's collection can qualify as a database, but there's no copyright on a single piece. As well, if of course we think about the Pompidou Center, we are talking about artistic pieces that we may like or not, but copyright as in on the single individual pieces. So I think that in the GLAM acronym, gallery is used to focus on the collections of artistic works, while museum is broader. I don't know if you...
Yeah, just to say that in the chapter, our contributor, Simon Stokes, looked at the private galleries. Yeah, you said. Yeah. So, where copyright, of course, is quite important. These are the questions.
Any more questions? I'm not sure whether we received any questions from the YouTube. Okay, that's via YouTube. We also have the live stream, but people might be able to comment there, but no questions at this point. Oh, okay, Simon.
Thank you. Can I ask a question to the first speaker?
Maurizio,
yes.
Of course.
If he is still somewhere available.
Where is Maurizio? Maurizio. Dov'è Maurizio?
Yeah, I'm here. I can hear you.
Hi. Hello.
Ciao Maurizio.
Now, should I look behind me or should I look in the front? I have no idea. Okay, I'm going to watch you, but you will probably just see my back. A short question. Do you think that the Data Act and the Digital Markets Act might solve some of the issues that you mentioned about the last phase, the phase since 2013?
I think what I mentioned in my presentation, the certain obligations on transparency of algorithm, this can have some effect, and in fact this is the provision that is most feared and opposed by big tech companies. So but I think, of course, is not sufficient, because in the DSA it requires some steps. Of course, it gives some power of investigation to the Commission to request a disclosure. So it's not a disclosure by default, which would be preferable, but this would be, a goal that is very difficult to achieve. At least some powers to request disclosure of algorithms. So I think this is a step in the good direction, but I think we need to move ahead, because the technology is always quicker than legislation. So by the time legislation kicks in, the big tech companies will have found another way to keep another layer of secrecy on top of what is required by legislation. So, but yes, it's a step in the right direction, in my opinion.
Yeah, I also have a question to Maurizio that relates to what you, towards the end of your presentation, you presented this approach towards reciprocity, this share-alike approach. What would you say if I would then argue with the rationale of copyright protection, actually, to say that, well, you now have Google that's doing this scans of the books, and I imagine this costs millions of dollars to do this scanning processes. And if you then say, well, they need, within this share-alike approach, make it freely available, wouldn't then there be also the possibility, if the outcome is that you can't commercialize it, then maybe there is the chance that nobody in the first place is scanning, is digitalizing these works. And I think this will also not be a good outcome if this would be the case. And also, a second question to this share-alike approach, would you go so far to say, well, if you now write a book and you want to sell the book, but in this book there is one Creative Commons photograph, does this share-alike approach then mean you cannot sell the book because there is one Creative Commons photograph in it? What's your thoughts on that?
On the first question, I think we should stop considering using exclusivity to reward investment. I think this is the wrong approach. This is the approach that has been very much promoted, not that much in the classical copyright regime, but more in the neoliberal copyright regime that took place in the 90s and in the 2000s in the EU harmonization process. I mean, the obvious example is the database directive. No, there is some investment, so we reward investment with exclusivity. So, of course, Google is making a huge investment, but we should not reward this investment with exclusivity, neither legal or de facto exclusivity. So I think this is the wrong approach if we want to preserve the commons. On your second question, I'm not sure how to respond. Yes, I think this is a problem that we found everywhere in copyright. So copyright is always a sort of a Russian doll where you have various copyrights, various licenses overlapping in one single product. perhaps the default rule is that the most open license should prevail in case there are some overlaps. So, but speaking of Creative Commons, another way which is now enabled by the new Article 4 of the DSM directive, the text and data mining, is that also text and data reproduction for the purpose of text and data mining can be made conditional to share alike, for example. So that this has an impact on what I was calling the monopolies on the secondary market of artificial intelligence and so on. So I don't know if I responded to your question.
Yes, Philip seems to be satisfied with your answer. Any final question? Okay, there's one more from Radim, and then we take a break.
Okay, thank you. Radim Hrvat, Masaryk University, Faculty of Law, the Czech Republic. I'd like to ask about the panorama exception. It's an interesting topic to me. My question is simple. Did you analyze some of the various cases from the member states, how this exception is interpreted, especially some, let's say, very threshold or bizarre cases, like taking pictures from above on the basis of drones, for example? Or I read some German cases that it doesn't fall within this exception if someone takes a picture from the backyard of the house because only front part of the house is visible, so that's fine, but no one can sneak into the backyard of the house and take a picture of there. Did you cover these, tricky cases as well?
Thank you.
Well, thank you for this question. So perhaps I can just very briefly provide some information about our data collection and analysis method, because the thing is that to receive this data from EU member states, we are relying on our national experts from different countries. So in that case, we mainly asked about the provisions in their original language as well as their official English translations, and this is what we have been focusing on. But of course, our experts have also provided us with some case law, but we have collected this case law in the original language. So which means that, us, if we're not speaking the language of that specific EU member state, we didn't have a chance to go through the case law. But again, some of our experts have provided us with some brief descriptions about these cases, and indeed, there are quite interesting cases as well. There is one that I can recall from Greece, where actually the court decided that exactly the same as the German case. So basically, the press cannot jump over a fence or jump over a wall and then go and take a picture or reproduce or create an image of a publicly available work, or that is not even can be seen by the public without necessarily putting any additional effort. Or in another case, it was possible to make a picture of the front of the work, whereas the back side of the work wasn't visible to the public. So this is why, this was left. The back side of the same subject matter was actually left out of the scope of this exception. So there are quite interesting cases, but perhaps we must also know that some of those are quite old cases that also predate the adoption of the InfoSoc directive. So this is why we were also referring that some of these exceptions have to catch up with the digital agenda of the EU, as well as they have to catch up with the needs and expectations of the digital era. I hope this answers to your question.
Thank you very much.
Okay, I would recommend to switch from freedom of panorama to freedom of coffee break. So this is probably the right time to finish here, and I would recommend to convene again in 30 minutes, so 15 past 11, and let's continue with the GLAM questions after that. Thank you.
Good morning again, everyone. We can resume right now with the second sessions related to GLAMs at home. We are going to have 3 presentations in a row right now. And we will start with a presentation focusing on access to culture and the out-of-commerce works, so a focus on Article 8 of the Digital Single Market Directive. Our first speaker is Svetlana Ivanovic from the University of Sarajevo, where she is assistant professor in IP law. Svetlana, the floor is yours.
Thank you. Hello, everyone. It's my pleasure. It's my pleasure to be here today. I want to thank Professor Mezei for inviting me. It's my first time here, and it's my first time in Szeged, and I hope it wouldn't be the last. The title of my presentation is Digitization of Cultural Heritage, Access to Out-of-Commerce Works. Digitization is a process of converting information into digital form in order to preserve the digitized content for the future generations and enable access to these works. Cultural heritage institutions like libraries, museums, archives, and other institutions conduct digitization in order to preserve content from physical deterioration, as well as adapt to modern technology and provide access to their collections via the internet. Their focus is on older materials, which would not otherwise be accessible. Digitization involves the reproduction of copyrighted works, making copies of works, and also communication to the public if the digitized content is made available to the public. Therefore, copyright protection is often regarded as an obstacle to the digitization process. Directive on copyright and related rights in the digital single market prescribes few rules which are relevant for digitization of cultural heritage. Firstly, Article 6 of the DSM Directive prescribes an exception for preservation of cultural heritage. Cultural heritage institutions are allowed to make copies of any works or other subject matter that are permanently in their collections for purposes of preservation of such works or other subject matter. Apart from exception provided for preservation of cultural heritage, directive provides special rules to the out-of-commerce works. Out-of-commerce works are works that are still protected by copyright but are no longer commercially available. In the past, we used the term out of print, but nowadays there are also electronic channels of commerce. Books can be available in electronic forms, so we use the term out of commerce. A work or other subject matter is deemed to be out of commerce when it can be presumed in good faith that the whole work is not available to the public through customary channels of commerce, after a reasonable effort has been made to determine whether it is available to the public. That is Article 8, Paragraph 5 of the DSM Directive. The question is how copyright work may become commercially unavailable. For example, the right holder decides not to publish new editions or to sell copies through the customary channels of commerce. Also, the right holder begins to sell an updated version of work, like video games. There is also a possibility that works were never intended for commercial use or they have never been exploited commercially. That also depends on type of work. Books, music and films are mainly intended for commercial purposes, and other works like paintings, drawings or visual artworks may not be initially in commerce. Cultural heritage institutions need to determine whether a work has been available to the public through customary channels of commerce. In other words, they have to make reasonable effort to determine whether the work is out of commerce. On the other hand, Directive on certain permitted uses of orphan works provides that cultural heritage institutions should carry out a diligent search in respect of each work or other protected subject matter in order to establish whether a work is an orphan work. It is obvious that reasonable effort requirement for out-of-commerce works is lower threshold than the diligent search requirement for orphan works. As a rule, out-of-commerce works are all books, audiovisual works, sound recordings, works of arts, or other subject matter that cannot be found in commercial channels, or they are not currently the subject of publication. In that circumstances, finding right holders, negotiating and obtaining license to use works can be very difficult and can slow down the process of digitization. Due to the fact that requiring copyright permission from each individual owner would be very difficult, Article 8 of DSM Directive provides two possible options for cultural heritage institutions. The first option is to agree a non-exclusive license for non-commercial purposes with representative collective management organization, which extends beyond the works the organization represents. That is, works created by copyright holders who have not mandated the organization to represent them. Additional conditions are that the collective management organization is sufficiently representative of right holders in the relevant type of works or other subject matter and of the rights that are the subject of the license, and that all right holders are guaranteed equal treatment in relation to the terms of the license. The second option is a mandatory copyright exception, where cultural heritage institutions can make available out-of-commerce works or other subject matter that are permanently in their collection for non-commercial purposes without concluding a license, provided that there is no sufficiently representative collective management organization. This option requires that the name of the author is indicated unless this turns out to be impossible, and that cultural heritage institutions only make the out-of-commerce works available on non-commercial websites. Member states may choose specific type of licensing mechanism in relation to out-of-commerce works. One of them is the extended collective licensing scheme that has already been implemented in national legislation in some member states. Another option is presumption of representation, in which right holders are legally presumed to have chosen to be represented by relevant collecting society. It is assumed that the relevant organization represents the right holders in that particular field, and therefore may grant blanket licenses to users, which extends to all right holders, even those who have not explicitly mandated the organization. Extended collective licensing enables the user to negotiate with the collective management organization for a license on behalf of right holders. The right holders of a particular category have granted the collective management organization authorization to collectively manage and negotiate the licenses. They require a high level of membership from that specific group of right holders. Extended collective licensing schemes extend the license granted by organization to a user to include works that the organization does not manage. The key issue for the legitimacy of the licensing mechanism is that collective organizations must be sufficiently representative. Member states should decide what is necessary for organization to be considered sufficiently representative. According to directive, they should take into account the category of rights managed by the organization, the ability of the organization to manage the rights effectively, the creative sector in which it operates, and whether the organization covers a significant number of right holders in the relevant type of works who have given a mandate allowing the licensing of the relevant type of use. This is recital 48 of the DSM Directive. There are no precise criteria for the assessment of the representativeness of collective management organization, but that should be organization which has significant number of right holders or most members within a certain area. The right holders may use opt-out mechanism and exclude their works or other subject matter from the licensing mechanism or from application of the exception at any time. This possibility raises a number of issues. Right holders have to be aware of using their works, especially if they want to restrict it. On the other hand, there is always risk for cultural or heritage institutions that conducted the digitization process if right holders wish to opt out. Some authors point out that the extended collective licensing with the possibility of opt-out functions as a presumption of transfer of rights to the collective management organization. Opt-out mechanism provides the means for right holders to withdraw their rights from organizations and put works in commerce. That is partially in line with the earlier case law of Court of Justice of the European Union. In the judgment Solier and Duke, preventive nature of copyright was emphasized in order to rule out the opt-out mechanism of the French law on out-of-commerce works. Implicit consent of the author as a possible legal basis for use of work is accepted in directive. According to the decision, the circumstances in which implicit consent can be admitted must be strictly defined, and every author must be actually informed of the future use of his work by a third party and the means at his disposal to prohibit it if he so wishes. But directive's approach on this issue is much more flexible. Article 10 provides publicity measures, information for the purposes of the identification of the out-of-commerce works covered by a license or exception, information about the options available to right holders, as well as information about the parties to the license. The territories covered in the uses shall be made permanently, easily and effectively accessible on a public single online portal managed by the EU Intellectual Property Office. Extended collective licensing and also opt-out mechanism may be deemed contrary to the monopolistic and exclusive nature of copyright. That mechanism may pose limitation to the rights, but it can be useful and sometimes the only solution if there are difficulties in finding right holders. Where there is no collective management organization for a certain type of work, or where organization is not sufficiently representative, cultural heritage institutions can make works available to the public under harmonized exception and limitation. And finally, to conclude, the legal mechanism established for out-of-commerce works introduced by Copyright Directive on Digital Single Market is response to mass digitization of works which are part of cultural heritage. The question is whether a similar mechanism could be established for other forms of the digital use of protected works. Copyright cannot be enforced and efficiently protected in the digital environment, and therefore extended collective licensing and certain forms of limitations and exceptions could be a solution in circumstances where we can not enforce rights effectively, especially for digital uses of copyright protected works. Thank you.
Thank you very much, Svetlana, for this exhaustive presentation of such a complex clause, and also for having provided a context to that. Article 8 is complex enough. Yeah, it's still working. It's complex enough, but you still need to connect it to other article like Article 10 or Recital 48. But also, I really appreciated how you give an historical context. Think about the once upon a time out of print work in the early 2000s, and then we had to wait for like 12 years for the Orphan Work Directive, then 4 additional years for the Soulier case, and then eventually back in 2019 we had this clause. So this is just an evidence about how complicated the regulation, the regulatory intervention may be, but it's extremely essential in this field, because I had the chance to follow Maurizio Borghi's presentation last month in Rome, and it was having some data about how many out-of-commerce works we have. Are out-of-commerce related rules facilitating the accessibility, the inclusivity of of the for the access to culture, or maybe should we need an even broader clause to cover all the cultural heritage and not just the cultural heritage institutions material? That's probably for the discussion a little bit later. But now we have with us, ready? We have with us Francisco Duque Lima, who is a researcher at the CTIP KU Leuven, and is going to follow up on Out of Commerce works, but in a different perspective. And more precisely, he's going to talk about vintage video games and IP protection. Francisco, the floor is yours.
Well, thank you, Peter, and thank you, Istvan, for the invitation for the organization. Thank you, Cristiano, for not butchering my long name and for the introduction. And to the remaining panelists, thank you very much for being here. So, my name is Francisco. I work for the KU Leuven Center for IT and IP Law, and I'm involved with the inDICEs project, one of the co-organizers of this workshop here. Essentially, we also do research on cultural heritage and copyright, especially my work package, which is work package 2. And today I will be talking about a specific subject matter, which is abandonware. This is abandoned gaming, or at least software in a more broad definition. So to get it started, I want to start with a case scenario. So this is John, and this is his son, John Jr., okay? John Jr. has recently become involved in gaming, as many youth do, and apart from the great hit Fortnite, apparently he's been playing a game that, if you're from the 90s or the 2000s, you're acquainted with, which is Sid Meier's Civilization. John is absolutely ecstatic about this, right? Because he used to play this in 1991, so he wants to show his old game to his son. He goes into his attic and he finds an old diskette, and he's like, wow, I can finally show this to my son. My Atari ST even works, everything is okay, except it doesn't. So the game is not compatible, he calls the number on the diskette, and they don't take it. Trust me, I called the number just for this segment, so they don't take the call. So he goes to a little bit more research, and he finds out that the game has been acquired 6 times, filed for bankruptcy another 4, so stuff is in a muddy terrain right now. So he calls the now acquirer of the initial developer, and they tell him, man, it's been so long, like, of course we don't have a copy for you. So now John is faced with a copyright morality, quote-unquote, problem. So he can either buy a copy, an original one, for $250 on eBay. He can go all the way to a museum somewhere and see if they have a copy and see if they will allow him to play that copy, or he can just Google search and play that online, right? But John knows this is a copyrighted work. We also do know which option John picked, right? So this is the problem with abandonware. Abandonware is essentially, well, considering video game as cultural heritage, it has a very short lifetime due to, well, the decay of the object, the fact that, well, whole hardware also gets extremely old with time. And we identified all these issues in the case study. But when you look at what you can do about this and what John can do, you're taken to this is piracy, this is hacking. Oh, sorry, my pointer has gone a little crazy. Wait, sorry. Oh, oops. I think this is fine now, right? Yeah. Sorry, I was on a roll. Okay, so when you're faced with all the issues from our case study, you are faced with this is piracy, this is hacking, this is illegal problem, right? So today we will be going through 6 main points. We will define abandonware. We will investigate how institutions and individuals engage in the preservation. One of the techniques for that is emulation, which has a lot of copyright implications, especially with the circumvention of technical protection measures. We will then understand how the out-of-commerce works regime helps on this and get some key takeaways for the future. So, as I've mentioned, abandonware is essentially, well, software that's been abandoned. This occurs mainly because, first of all, the medium that it's placed in is extremely, has an extremely low life expectancy. There's material decay of the plastics. There's also a thing called bit rot, in which the material inside of the diskettes or the disks will, well, succumb to entropy. And essentially, there's also the problem with the hardware that can read them. So getting the games into a stable media is only half the problem. You also have to have the consoles that can read them. There's also commercials interests involved, right? So if you're just patching old games, you're never selling anything. So essentially having an obsolete game from time to time will get you to sell new ones. And this is also, oh, I'm sorry. I will just use my computer for this. Okay, there's also a great event in the 1980s that is the Great Game Crash, in which a lot of developers went to bankruptcy and they just threw code away. So essentially it's very hard to find old copies of source code, and also the games that are stuck in your attic just decaying are just losing and eventually disappearing, right? In terms of the legal perspective, there's ownership disputes, a lot of problems with the acquisitions of companies and the developers that transition from a company to another. There's a problem about not knowing who the owner is, and there's a thing that I like to call copyright attachment. So even if companies are not exploiting their IP, they are simply just attached to the fact that they can, and so they will not allow the public or anyone else to do. So it's kind of, I would say, ironic that a company that is constantly removing digital storefronts and making articles unavailable to the public is also the one cracking down on the efforts of the community to keep them available. Kind of remembers you of a certain fable of a miser that buried gold so that no one can use it poor, right? So, moving on. The only way to counter this is, of course, through preservation. From an institutional perspective, we divide preservation into three approaches. One about conserving the artifact, one about conserving the artifact as a tool, so allowing people to play it, and because it will eventually decay, you learn how to fix it, you learn how to patch it, and one based on the content itself. The one that I want to talk about is the third one, because it's the one that's most effective to keep the longevity of the article. There's two approaches to this, so how to conserve the content of a game. It's porting, in which you just convert the software from one platform to another, and emulation, which is simulating the environment of the old console to use it on a future system like a computer. So, you know, those kids playing Pokemon games in their phone, that's emulation. But there's a lot of actions involved with the emulation task that are essentially associated with piracy, like cracking. You've heard of cracking and ripping and all of this. So here's how we enter into this. Emulation, first of all, it's interesting to mention that the average life cycle of one software article, especially in the game scene, is 5 years, and that because computing power is also increasing in consoles. This means that emulators are only usually possible around the 4th year of the game's life cycle, so by the end of the commercial exploitation. And that it's essentially, and this will be an important point further on, developed by communities, all right? Developed by people in communities interested in preserving. Even though there's a small portion done by institutions, it's still done by people, okay? And by now you're thinking, well, where's the copyright in this? And well, we all know that copying source code and even decompiling will be 2 different copyright infringements, so specifically the reproduction or the adaptation of a work. The way that people kind of try to avoid this is through a thing called clean room technique, in which one developer will describe the function of code to other that hasn't looked at the code that will code it. It's a little weird, it works, but still there's one thing that we're missing. Even if you can provide for emulation of an old system through the clean room technique, you still have to read the games themselves, right? And this is only done through the circumvention of technical measures. Even if you're decompiling code legitimately, you can still be considered to be infringing on someone else's copyright, specifically the legitimate interests of the rights holder for economic exploitation, even if they're not exploiting the copyright, right? So, about circumvention, I will give you a quick rush through this. So, in 2001, we have the Infosec Directive. We are familiar with this. We are familiar with rights management, information, and their protection. And in the other side of the Atlantic, the MCA is now being amended to allow people to bypass technical restrictions in case the article is obsolete and is not accessible, right? So after this, we have the Software Directive, in which we say basically the same about technical protective measures. The Nintendo PC Box one, I'm not going to approach this case because I don't like it, and essentially they lay down a couple of requirements for proportionality of technical measures, but no definition on that, so we're stuck on the same loop. Then, in 2015, another amendment in the other side of the Atlantic, so that if you're stuck outside of a server, now institutions can make their own servers for games to keep running. So while we're still here battling and protecting technical protection measures, the US is there allowing people to bypass all of this in order to allow for an experience on the public side. Another, the MCA exception, that does exactly the same. And we reach 2019, where we have literal reversion finally. So what do we have in 2019? We already approached this. We have essentially Article 6 and Article 8, the most useful for this purpose. And I want to talk a little bit about these. So Article 6, we all know, or we already know what it's about. It's about allowing institutions to do copies of protected subject matter for preservation purposes. And Article 7, which legal override, says that the first, third, and fifth subparagraphs of Article 6 of the Infrastructure Directive applies. So this is their little labyrinthine approach to protection measures. This is what it says. Member states have to take appropriate measures to allow the beneficiaries of exceptions to benefit from their exceptions. So essentially, if you're supposed, Article 6, to be able to reproduce a work, in this case, you can and not be hindered by a contract or by technical measures. So in this case, institutions can bypass that just for the reproduction, right? But how do they make it available to the public? We already had spoilers earlier with Article 8, so I will not bother you with this one. We already know that can use out-of-commerce works that are in their collections to reproduce, distribute, or make them available in the public in their non-commercial websites, right? I can skip this entire slide because we already had a great explanation on how it works. So I will bring you some main concerns and how does this apply to the case at hand, to abandonware. So are these things that we're talking about even included in the scope? This has been a conversation that has been going for a while with orphan works. People would say, no, it's only audiovisual works, so it's movies and songs. Don't bother. The category is there in the platform, so at least they've done this for us this time. The second question is, well, as we have explained earlier, or as my colleague has explained earlier, the first licensing mechanism needs collective management organization representativity, right? But are there even CMOs for developers and game publishers? The short answer is no, which is a bad thing because you're losing one mechanism. The good side is that you can still rely on the exception. Part 3 is, well, most of these are made in the US and they're imported. So how can they display them, right? This only considers, or this only concerns works done in European member states. Well, that's true and it is also not, right? Because if the company has a HQ in the European Union space, they can still benefit from this. And even if the CMO considers itself to be sufficiently representative, the CMO that doesn't exist, so we have a problem here, this can also apply. And the last question, if the publishers have been so protective of their copyright, if they're cracking down on emulation and all of this, how do you know they won't just use the opt-out mechanism every time that a CHI just makes their products available? And this is, I think, the hardest question of the day, because on one side, copyright attachment can lead to this. On the other, I think that copyright attachment really depends on the fact that they view everything as piracy, and using a legitimate institution to do this cannot be considered piracy in the company's eyes, right? So maybe John and John Jr. can play the game, and there's still a few remarks I want to make. I know I'm done with time. This is Peter right now looking at me, but it will be quiet. So, okay, perfect. So the key takeaways from this. I have a few remarks on how this can be improved. The out-of-commerce works framework is great for this, and I hope something will come out of it. But there's some things that we should include in the debate for the future. The first one is you're not using your source code if you're retiring articles from the market. Make them available so that people can learn how you did things and can use it for their own development purposes. The second one is there's legal deposits for a lot of works. So why are you not depositing source code, or at least the articles, when you are introducing them in the market? The third one is, this is a conversation that's happening all the time in the US, and we should have it here, affiliate archivists. As I mentioned, the community is one of the big parts of this conservation task, and they have developed the resources in their grassroots mission status to individuals so that they can continue their tasks, or at least collaborate with institutions. Get some good exposure from it. Someone will do if you don't, so don't bury your gold, maybe make it available on the internet. The fifth one is we need to talk about copyright term eventually, right? Because we know how it works, and it's been a long discussion, and it's been changed many times. But if you have a life expectancy of 5 years and no economic exploitation afterwards, but still deprive the public from having access to your resources, is the term really balanced in this case? And my last remark is, if you're cracking down on circumvention, even if it's just for research purposes, or even if it's for all of we just mentioned, the provision only says that member states have to create some kind of structure for you to benefit from your exception. But this is not mandated or at least set down anywhere, or this is not developed anywhere. So we also need to have a talk on this and to kind of balance out technical protection measures. So I'm closing off my presentation with a small quote, which says, "Not providing commercial access is understandable, but preventing institutional work to present these titles is actively destructive to video game history, and in my sense, cultural heritage in general." So, thank you.
Thank you very much, Francisco. You closed perfectly on time. So thanks for these very rich presentations that once again enlightened how difficult to understand legal rules might be. And in addition to the challenges of understanding legal rules, we also have the resistance of technical aspects, of cultural behaviors, and also of logistic aspects. One of the things that emerged from this presentation is that preservation is challenging, but again, if we focus just on preservation and not on access, dynamic access or disseminations, in any case, it's going to be very hard to enable the access of cultural heritage. And another very broad remark related to the first part of your presentation is when you were referring to the morality of copyright, when things are too complicated, what do? Do I leave or do I infringe? Yeah, that has to do with the social value of legal rules, which is something that is extremely essential and crucial nowadays more than ever. Thank you again. So according to the program, there should be now a presentation again on video game, on different aspects of video game, but the presentation is not going to take place. It's going to be available online, so it's going to be a virtual presentation. You're going to enjoy it a little bit later.
Good morning, and thank you very much, first of all, to Peter Massey for the opportunity of participating in this 6th edition of WIPS with this video. Sadly, I cannot be with you. I hope we'll meet face-to-face in the 7th edition. I'm going to talk about the cultural preservation of video games according with cultural heritage rules in the Spanish law. Because, well, video games are nowadays part of the offer of our entertainment. Many aspects of this sector are also part of the popular culture. Some video games IPs are as valuable as cinema, television and literature ones. However, in the 70s and the 80s the situation was different. On the one hand, computers were an expensive product and focused principally, first of all, in work. On the other hand, video games were perceived as toys and their selling was oriented to children. Entertainment software was not considered part of the great culture, but disposable goods, as cinema or television in the past. Despite this, we can find in countries like the United Kingdom of Spain examples of youngsters that founded software companies that are part of the history of video games. Titles like Manic Mina, programmers like the Stamper Brothers, and marks like Ocean Software were well known. In the case of Spain, the 80s are marked as the golden age of video games industry. Computers like Spectrum and Astra series were very popular, and there was also place for Commodore or MSX, the computer from Japan. Between 1984 and 1992, many companies compete for controlling the Spanish market, but having little success exporting their products abroad. The end of the long-extended hegemony of the 8-byte format also supposed the rapid decline of the sector and the finale of a glorious period never repeat. This, La Pulga, is the first official Spanish video game from the year 1983, and it's the first step in the way of this golden age. Here we have some companies, many of them were founded in the middle of the 80s, and many of them disappeared in the beginning of the 90s. Maybe the longest one was Dynamic, maybe the first and maybe the last, but all of them, the glorious period is almost the same, with some exceptions. But to establish an example of this situation, computers are expensive and video games are for children, and actually they are not culture, we can have the example of La Abadía del Crimen, a title of the year 1987, and for many people, me also, the best video game in the history of the Spanish software. The idea of the La Abadía del Crimen needs a little remembrance about the copyright economic rights, because, well, we have, remember, reproduction, public performance, recording, broadcasting, translation, and adaptation. We are going to take that. Because the authors of La Abadía del Crimen wanted to present this game as an adaptation of the novel of Umberto Eco, Il nome della rosa, the name of the rose. Well, but the titles are different. Why? Because when they ask Eco for the authorization, so the game could be a derivative work of the novel, there are two versions. No answer and a negative answer. At last, the conclusion is the same. No authorization. So they decided to go ahead, doing some changes. First, the title, from El nombre de la rosa, El nome de la rosa, the name of the rose, to La Abadía del Crimen. But the first title that Eco wanted to give to his novel was actually La Abadía del Crimen, in the Spanish translation. The main character, from William of Baskerville to William of Ockham, but originally Eco thought about the possibility of William of Ockham as the main character. After that, he changed the idea because, first of all, he didn't like very much the Venerabilis Inceptor, and secondly, he wanted to pay an homage to Sherlock Holmes. And the book was changed from the second book of Aristotle, Poetic, to the Coena Cipriani. The Coena Cipriani is an important book in the novel, but not the most important book. But it's present in the novel. So these changes were principally aesthetical. But on the other hand, they not change other aspects directly taken from the novel. For example, the time slot, 7 days, the plot, the inquiry about some murders of monks, and at last, the library as a forbidden place, built like a labyrinth, or as a labyrinth. So, to tell you the truth, I think that there are many violations of IP rights, of copyright in this video game. But maybe because it was not a success. Maybe because video games were considered in these days as toys. No one noticed it or no one cared, because no one, nor Eco, nor a representative of Eco, claimed or sued OperaSoft, the distributor, or the programmers for these violations, this vulneration of IP rights. I think in this moment the situation should be, or could be, very, very different. But well, This is not time for Ukrainians. At last, well, this is an example, and as I said before, the golden age of Spanish video games came to an end at the beginning of the 90s, but not many years after that, maybe at the end of the 90s, began a movement of reivindication of the legacy of this period. For example, the co-author of Bugaboo, La Pulga, created the last year a new version of the video game for Steam and the Google Play Store. And, for example, two programmers created a remake of La Abadía del Crimen, taking more aspects of the novel and also from the picture. The film, directed by Jean-Jacques Sano in 1986, is an extended version with more characters, more clues, and the soundtrack of the film. I have to say that it's a clear example of the wrong perspective or wrong idea that many people have about the IP rights, because, well, this game is free. Authors are not earning any money, but we all know how copyright goes, and this explanation is not a justification for using without authorization, not even in the name of the remake. There is no justification for taking protected works by IP law. But also we have books about the history of computers, Spectrum, Amstrad, about the history of companies, history of Dynamic, or the history of AD, about some kind of games, interactive fiction, La Aventura Colosal, and also focused in La Abadía del Crimen, Obsequium. All of them are very, very recent books. The oldest one is from 2016, and all of them have been written by people that were children when these games and these computers were in the market. So maybe an excess of nostalgia, maybe, but also a representation of the importance of Spanish video games from the 80s in the Spanish culture. For example, we can see this, an homage by the National Company of Mailing to La Abadía del Crimen 5 years ago, a commemorative stamp series of the 30th anniversary of the start of the publication of the game. Not bad for a cult game. And at last, the National Library of Spain is looking for video games. This is a company looking for video games. Estamos buscando juegos. Can you help us? ¿Puedes ayudarnos? Because they are trying to apply a rule from the Legal Deposit Act. Because they say the bibliographic, sound, visual, audiovisual, and digital heritage of Spain culture is one of the richest and most representative in the world, and must be preserved for the benefit of present and future generations. There is a recognition, a declaration of video games as part of cultural heritage. So, wow, this rule and the library are only applying a constitutional mandate, a constitutional obligation. Public administration will grant conservation and promote enrichment of cultural, historical, and artistic heritage of all Spanish people and their belongings, regardless of their juridical nature of ownership. the protection of cultural heritage in Spain, is developed through many acts, regional acts, and 2 national acts about material and immaterial cultural heritage. So now, video games, with the condition of antiquity and especially historicity, must be preserved, must be protected, must be conserved. How? Well, maybe we could begin with the protection established by the IP law. Video games are computer programs, so we are going to protect the sequence of instruction, the preparatory documentation, the technical documentation, the user manuals, and the successive versions. But in the cultural perspective of video games are only computer programs. For example, with Megacorp, this interactive fiction, there is also a plot, a history, an interactive history. We as gamers are part of the history. And this is an aspect of creativity, of originality, that shall be protected beyond the concept of the code, the documentation, the version, the manual. But also, we have to protect the packaging. For example, these covers from Alfonso Aspiri are part of the history of the Spanish video game software, because they contributed to sell many games. We have here Camelot Wars and Simple Profanation, 2 video games, and 1 book, a compilation of all covers made by Aspiri between the 80s and the 90s. So, this artistic, pictorial aspect should be protected also. As a conclusion, I think that video games are another example of the transformation from immediate consumer products to part of the cultural heritage. As part of the digital heritage must be preserved. But in the process of preservation, we have not only to protect the aspects included for computer programs in the IP law, but also every accessory element relevant from a cultural point of view. Thank you very much.
So we are going to switch to the very last presentation of the morning. We are going to switch to Bohdan Vodje, who is a researcher at the Jagiellonian University, and we are going to slightly change the topic. We are going to focus on critical editions, how to protect them, and also this very exotic thing, which are first editions. Bohdan, the floor is yours.
Okay, thank you. I have to say, after Francisco's presentation, I was John once, and it was tough. But getting back to my obscure topic, so the forgotten rights that I mentioned in the title are 2 rights that refer to the so-called first editions, or first publications of works in the public domain, and scientific and critical editions. I call them forgotten because when I was writing my PhD about them, whenever I told people what I was writing about, the usual response was, what? So if that was your first reaction, I don't blame you. But so if they are forgotten, if we say, what? Why should we care? I think there are at least 2 good reasons why we should care a little bit about these objects of IP rights. First of all, what we are dealing with here are 2 rights that were specifically designed to take something away from the public domain. That's not by accident, that's by purpose. And secondly, even though they were applied only very rarely, if it happened in connection with an important cultural object. So a couple of examples. In Germany, there was a case involving the Nebra Sky Disk, which, as far as I know, is one of the oldest, if not the oldest, depiction of the night sky. It was entered into the UNESCO Memory of the World Register a couple of years ago. There's also a case about an opera by Antonio Vivaldi, which was deemed to be lost, and then copies of the notes were found in the early 21st century. There were cases about a very optimistic guy called Arthur Schopenhauer and an edition of his collected works. And outside the EU, we had perhaps the most famous case about editions as such, the Dead Sea Scroll case that was decided in Israel. And in all of these cases, this is just a small sample, but in all of these cases, we had something that was in the public domain and somebody tried to take it away from there. So how can such stuff fall out of the public domain? In the EU, first of all, we need to turn to Article 4 of the term directive. So essentially anyone who publishes for the first time or communicates to the public a work that is in the public domain and is unpublished, whoever does it, no originality requirement, no substantial investment requirement, whoever is the first to do it receives protection essentially equal to economic copyright for 25 years. So this right was introduced in the early 1990s. The idea was to incentivize making such works available to the public. Back then, perhaps there was some reason behind it because it wasn't so easy to digitize and make works available to the public. Right now, it's slightly more questionable, perhaps. How was it applied in practice? So the Nebra case. The Nebra Sky Disk was decided by a German court, and the disk was probably an object of religious cult about 4,000 years ago or so, but the German court considered it to be an unpublished work. The disk was unearthed by quote-unquote unofficial archaeologists and then recovered by the German federal state of Saxony-Anhalt, and copies of the depiction of this disc were distributed among journalists who were present during a press conference. And according to the court, that was enough to be a publication. So the federal state of Saxony-Anhalt received the exclusive right for 25 years. Ironically enough, it helped them prevent a trademark with the depiction of the disc from being registered by another German municipality. In the Moctezuma case, there was a problem of whether the opera was a published work when it was rediscovered recently. And the court found that if we go back to the 18th century when the opera premiered originally, copies were distributed among musicians and were stored in the opera house. So this, according to the court, even though it happened in 17-something, amounted to publication, so no exclusive right could be granted. Now, does anything change after the CDSM directive? We all know Article 14, and we all know its origin. It was about non-original photographs. Does it happen to alter at all the situation with first editions? So this doesn't seem to be very much a focus of, I think, any European country that is discussing the implementation of Article 14. But there are no formal obstacles to take it into consideration because the CDSM directive essentially says that it leaves intact some of the other copyright acquis, but not the term directive in general. So the term directive is not mentioned in Article 1, Section 2. Can a work of visual art be an object of the exclusive right from Article 4? Well, the Nebra case speaks for itself, and if we interpret the notion of work of visual arts broadly, as I agree we should, then again, we have no obstacle. So my humble proposal is that we should take Article 14 into account when we decide if something dug out from the ground after millennia can be protected by this Article 4 of the term directive right. We could have a problem with a mixed work which contains text and, for example, illustration, but in such a case, of course, this exemption would only apply selectively to the visual parts, not to the textual parts. Now, on to the scientific and critical editions, and I have to make one distinction at the very beginning. I am not going to talk here about, for example, reconstructions of works, of artworks, of architectural works. What I'm going to talk about instead are what I like to call the unsung heroes of social sciences, like history, and of humanities in general. So usually scientific editions and critical editions involve textual works, literary works, historical sources, sometimes music, only exceptionally rarely such editions involve visual arts. And the problem here is that, well, the original carriers, the original copies, are often unavailable because they simply don't exist anymore. That doesn't mean that we don't have access to such old works, because other copies, prints, could have and usually have survived. However, such later copies, prints, can contain errors, mistakes that could have been introduced deliberately. For example, if in the case of censorship, or most probably, they have been inserted only inadvertently. For example, when we have a scribe or a typesetter make a silly mistake when rewriting, copying, when making the copy. And the issue here is that one of the primary purposes of such editions is to make available the work in a form that should be as close to the original as possible. And it requires considerable effort, knowledge, and skill to prepare such an edition. The editors will have to consult, compare various sources. Of course, they cannot consult the author to figure out what was originally written. So what they do is make what they call conjectures. A conjecture is essentially an educated guess, you could say. The editor will argue that the word or the phrase that should be inserted in a place where a mistake was introduced is the correct one, but honestly, they are never sure if they are really if this is really the right decision. So how can that be protected? In Article 5 of the Turn Directive, there is an optional neighboring right to critical editions and first editions, modeled after the German regulation from paragraph 70, I believe, of the German Copyright Act. However, this is only optional, with the protection capped at 30 years after the publication, and only a handful of European member states decided to implement it. We have it in Germany, the prototypical regulation. We have it in Italy, in Poland, in Estonia, Portugal, and Slovenia. I think I haven't missed anything. But let's agree that's not much. However, there is another elephant in the room, and that's copyright. What if these conjectures can be considered original enough that the entire edition of the text is going to be essentially a derivative work? So this is not unheard of. This is an excerpt from the case that was decided in the year 1990 by the German German Kammergericht. It involved the editions of Schopenhauer's works, and the court explicitly said that when the editor made decision about correcting the mistakes, it didn't only amount to the protection under the neighboring right to scientific editions, but it was original enough, according to the German then applicable standard of originality, to be protected by copyright. I like this decision because of how the court showed some of the back office of the editing work. For example, when the editor decided to replace the German word streben, that's, I believe, to strive or to try, with sterben, or to die, and told everyone that sterben was correct because it reflects Schopenhauer's pessimistic philosophy, and streben doesn't really sound well in this context. Now, in the Israeli case, of course, this is not EU, but what I like to point out that here the editor, Professor Elisha Kimron, filled the missing gaps because the manuscript was physically damaged, And then the court he argued that he arrived at the correct version of the original manuscript, and then when his edition was published without his consent in a journal, he still asserted copyright. And the Israeli Supreme Court sided with him and said it's not only about the effort, it's not only about the sweat of the eyebrow, it is also about making decisions that are free, and he had to apply discretion, and since he had to apply discretion, there is room for copyright. Now, where do we stand with this? Essentially after CGEU did to all of us, so after the CGEU decided to define originality. Because you could argue that with the current standard of originality, the neighboring right from Article 5 of the term directive has been silently interpreted out of existence, because if something is scientific or critical, it's also original. And again, people much wiser than me argue that this is exactly the point. For example, Professor Stamatodi and Professor Toremans in the latest commentary to the CDSM, they say exactly this. I humbly disagree. Why? Of course, there are parts of the editions that are undeniably capable of getting copyright protection. An edition will have an introduction of an afterword, some kind of essays, some kind of extensive commentary in the footnotes, and here we don't really have that much problem with originality. However, what about the conjectures? What about the amendments to the text? And if we take a closer look at how this works in practice, we need to first observe that the decisions, the choices that are made by editors are not completely free. They are limited, both in number and in quality. Why in number? Because there is a limited number of sources on which the editor can rely, and in quality, because each of these decisions has different arguments behind it. Arguments that rely on linguistics, on history, on the knowledge of, the general knowledge of the author's body of work. And here we come quite close to what you could call a scientific discovery, or more likely a social science theory, or figuring out what happened at some point in history. We don't protect arguments about historical facts under copyright, and I would argue that here we are dealing with a similar thing. So the idea-expression dichotomy applies, and the framework of the so-called European approach to merger developed in BSA and subsequent decisions, I think, should also be applicable here. The very fact that we have the right from Article 5 of the term directive, I think, should serve as an argument that the legislator assumed that there is going to be need for such protection, but it doesn't have to, nor should it be copyright, because copyright simply lasts for too long. What we also know is that some theories that appeared in the literature before CDSM and before InfoPack are no longer valid. In the German literature, some scholars tried to figure out this problem by saying that if the editor wanted to reconstruct the original, then we have the neighboring right to scientific editions. If the editor wanted to do something new, then we have copyright. However, after Brompton, I don't think we really can take the editor's intentions into account anymore. So I'm not arguing that there is no room for copyright here. There are cases known that in which the editors essentially finished an unfinished work for the author without relying on any external sources, and here, of course, there is room for originality. What I'm trying to argue, and this is going to be the last sentence of my speech, what I'm trying to argue is that we shouldn't be hasty about granting copyright protection, because that would be simply detrimental to social progress, as much as granting copyright to ideas in technical measures would be detrimental to technical progress. Thank you.
Thank you very much, Bohdan, for this very inspiring thought. Basically, you know, what Bohdan enlightened is that we started from a control-based paradigm, but that was in the 90s. Then things change, and we are now in the third decade of the 2000, and we now have Article 14. So one of the main challenges in the future is to answer the question, how much room should we devote to creativity? How much room should we devote to say that creativity is there? How much room should we devote to the neighborhood right protection? And how much should we leave in the public domain in a way that is balanced and is not detrimental to the society interest including both economic and non-economic interest. And I think that there will be a lot to say in that, and overall, you know, the balance between what is gonna be shared, circulating very widely, and what is gonna remain under the protection, should it be from copyright neighboring rights or more broadly speaking from other form of IP rights, is really gonna be the broad questions that we all have to face in upcoming years. In any case, I think that for the recreating projects, there's much more food for thought. And on a personal note, the fun thing is that Bohdan started his presentation by saying that these are the neglected rights. And yesterday we were having a conversation and actually say, oh, I'm actually researching on that. So going back to what Peter was saying this morning, this is the aim of this meeting is to be a workshop to establish connection, to, you know, to have a dialogue and exchange. And this is an evidence that it has already happened. Okay, so I now open the floor to questions and remarks. And we're perfectly on time, just to say. No questions, no remarks. Online, I don't know if there's something. Yes. Maybe the speakers want to come to the floor, to the stage, sorry, to answer. Or
Thank
just,
you. Sorry that I again ask a question. I'm sorry for that. As was already announced, as already told by Professor Borghi in the morning, I think that most people in the room will agree that copyright law is far from perfect at the moment. But we also all know that within the next decade or so, there will be no fundamental international changes as the DSM directive illustrates. However, the specific case presented by our last speaker, whose last name I will not try to pronounce at this point, showed that maybe it would be possible to change the incentive-based, the incentive system behind that specific topic of, call it copyright, call it neighboring rights, by maybe trying another system to stimulate people to comment on works, to recreate works, or to at least make works that are found available. But then I was wondering, what alternatives do we have? What do you think that would be viable alternatives to make sure that these works are made available in the end?
I'm very grateful for that question. It wasn't really a qualitative study, but I talked to a lot of editors when I was preparing my PhD, and they were surprised that they can have any protection at all. So they learned from me that there was a neighboring right designed specifically for them. So that kind of tells you how much incentive they got from the fact that this right existed in Poland. The works that the editions as such, as that we are describing here, well, very rarely, even though they may involve important cultural objects, they very rarely involve something that is commercially viable. So, at least from my knowledge of the Polish area of preparation of such editions, it's about public grants mostly. If you receive public money for research and for meticulously comparing, traveling from one country to another, getting digitized copies, and then spend hours trying to figure out which copy is the proper one, I don't think any exclusive right can serve here as a proper incentive. It's simply about public funding of the research, and the editors themselves, at least those with whom I talked, seemed more inclined to demand recognition from the moral rights point of view than getting exclusive rights modeled after the economic right. And ironically enough, neither the directive nor, for example, the Polish implementation or the German implementation or any other that I've heard says anything about, for example, so to speak, authorship of the edition. So that would be my answer. Is it also to me?
Yes.
Okay, so I'm staying.
It relates to what you were just saying, and Marta and I were discussing that your talk will nicely flow into the broader open science discussion, because especially the last thing you said about acknowledgement, the fact that people feel this more important than being credited economically, but rather morally, really is in line with this approach and the open science philosophy, which, since you are covering scientific works, should be definitely considered.
I think that this is both sides, the two sides, because one side, of course, are the editors themselves who deserve recognition. The other issue, also important from the scientific point of view, I could respond with an anecdote here. The very fact that I picked up this topic was because of my future wife, then girlfriend, who was studying textual criticism, and she asked me, how can it be that somebody put an edition of one of, I think, 16th century Polish works of literature, uploaded it to Wikipedia, but without recognizing the editor, so she wasn't allowed by her professor to use this edition in her assignment, because it was demanded from her that any edition used must be recognized, must be identified. So essentially, not recognizing moral rights can have, let's say, a larger public interest role, not only about the emotions of editors.
Any other comments, questions?
Yeah, thank you very much to all three presenters. Very, very nice panel. I have questions for the two last panelists. For Francisco, and I need to read the other name just to be sure, right? And Bodan, right? Yes. Thank you. So, Francisco, I found it very interesting that you raised the point on the morality of copyright. I mean, I am kind of a vintage gamer myself. The only games that I can play come from the 1990s. That's the most recent. I cannot really cope with nowadays games. I get completely lost and confused. And one of the games that I always wanted to play was the Cheetahman. It's probably labeled the worst game in history, right? Unfortunately, nonetheless, for all kinds of reasons that you mentioned in your presentation, I'm not able to play the Cheetahman because the company that made it kind of vanished right after they published the game. And nobody really knows who owns the software about it. And to be honest, I would have no moral dilemma myself. If a website were to make the game available, I would play it. Like I wouldn't worry of obtaining a legal copy, so to speak. And that is because I think that to a certain extent, sometimes many of these copyright laws might not make sense. But for me, I would like to take away back home is, according to your opinion, are there any mechanisms in current copyright law that would allow us to enjoy such games and such materials, and which these mechanisms would be? And the question for Bodan, I always have to confirm. I found it very interesting how you tried to, how you brought the idea, expression, dichotomy into the discussion about Article 5. And if possible, I would like you to elaborate a little bit further. How do you think it influences the interpretation of this article, especially in view of the fact that many commentators think that, in essence, Article 5 is trumped by the interpretation of originality given by the court?
All right, so I will begin by answering your question, and thank you very much for that. So your question perfectly validates the whole conundrum of the abandonware problem, right? And my short answer is no. There are no legal mechanisms to prevent that. That's why I'm suggesting them. But from a practical point of view, you've seen everything happening. You've seen people dumpster diving to get original cartridges that are being sent out by companies so they can extract source code so they can make it available. I mean, there's even that urban myth that Atari made the E.T. game, and the E.T. game was the worst game of all time, so this is my take on...
The Zitterman is worst, I completely
And that they buried it in a concrete parking lot, like 10 feet underground, and people thought, this is a joke. And someone went there to bury, and they were there. So we now have access to that, thanks to that effort. And honestly, there's nothing on that, because first of all, the company is entitled to do whatever they want with their IP, right? They're the developers, and if they go into failure or bankruptcy and they have no exit clauses for who has the IP after that, or there's no acquisition, you're stuck in a loophole. And that's the whole point for me of either deposit measures so that institutions can have copies and then they can make them available even if it is now an orphan work. And for the entire point of making works available when you're retiring, which is easy for if you're working with open repositories in the 21st century, right? So, unfortunately, my answer to you is there's nothing, there's suggestions on the table.
So ISO's still using all kinds of shady websites to download all kinds of shady versions, that's what...
I mean, you can look for the metadata online to see if an institution has a copy of that and if they're willing to digitize it and make it available, and in 7 years you might have your game, or you can just go to Google, right? So that's the problem.
Yeah, but you know, I'm getting older and older, 7 years is
I do get that.
But a question, on developing a solution, do you think that at some point the reasonable expectations of old school gamers like myself shall be taken into account eventually? Because the current regime as it currently exists, it perfectly represents, of course, the legitimate expectations of those that create the games and the software. But at the other end of the spectrum, there are people that want to play the games, and they can't.
Well, thankfully, the expectations of old school gamers like you and Bodan have been neglected for a while, and now people are starting to realize, well, this stuff is culture, this stuff represents that specific mindset of that specific time, this is a cultural asset, right? And institutions are getting more invested, and they will eventually start pressing on that subject. For now, I would say we're all getting older, and we're all kind of tired of waiting for that. You can see some discourse around it, specifically in the fact that, well, the out-of-commerce works provision included video game as a category, which is a first in the European copyright landscape, because the only other thing that you have is the Nintendo decision, and honestly, it's kind of bad. So, I don't know. I think people are starting to become aware of this as subject matter in itself, and they are becoming, it's becoming a discussion. I wouldn't say that it's going to be solved soon. There's some hints that in the next 2 or 3 years you will have some kind of decision on that, because there's a certain case lodged in the Court of Justice. But I mean, that's all conversation, right? For now, there's nothing. So that's my sad answer for you.
Yeah, thank you, thank you.
My turn. So while we are still on games, I must be a lucky guy because my favorite game from the 90s was made open source. But as for the question, your question enlightened me because it means that I wasn't precise enough. I wasn't trying to really apply the idea expression dichotomy to Article 5. I was trying to apply it to counter this notion that the modern version of originality trumps Article 5. I believe that protection under Article 5 can be granted to some extent for the effort that isn't original, and the question is if the person who prepares the edition is following, broadly speaking, sound methodological practices. So this is a completely different angle, which I don't think really leaves that much room for applying idea expression in terms of Article 5. So I hope that clears it a little bit. Christiana, while I'm here, may I use the mic to ask a question to Francisco? Yes. Thank you. So I was wondering, when I was reading Article 6 of the CDSM, it essentially only mentions the exceptions to the reproduction right and for preservation purposes. A question that has been bothering me and I have no idea how to solve it. Okay, let's say the institution can make copies, like backup copies of a video game to preserve it. But if there is a researcher in this institution who wants to run the game and play the game, in other words, reproduce the game temporarily for preservation purposes, does it make sense, or is it no longer preservation?
So that's an interesting one, and we could spend a lot of time on that. But I think what you're touching on is something that I defend, which is the fact that while you can make reproductions of works like books or images, and the reproduction itself is also the work, there's interactive works that necessarily need the interactive function to exist. So this is a thing that has its own copyright implications. To be honest with you, a reproduction in this sense would have to entail not only visual assets and sound assets or whatever, but code itself, and you can only know if code is properly reproduced by compiling it and running it, right? So I assume this is a necessary act for the preservation task. However, you will never know unless someone goes outside to discuss this, well, in court, right? Because this is not defined anywhere, and while I personally consider that to be an essential act for the process of reproduction, because otherwise, you will get a decaying copy and you will then realize when you're finally running it that you did a bad job. So you need that for the reproduction task. That would be my answer to your question.
If I may quickly add on that, I totally share the point of Francisco also, because I think that the key of Article 6 is to avoid going out of the premises. But as long as you stay in the premises, there is some tolerance to have an accessibility to a communication which is closely connected to reproductions. Is there any other questions? Otherwise, I would have one for Svetlana.
Excuse me if I may intrude in your conversation.
Yes. Maurizio, is that you? We don't see you, but a voice is coming from the floor.
Yeah, sorry.
Go ahead, please.
Okay, no, thank you very much for both panels of this morning. They were both fantastic, and I took a lot of notes, and I have comments and questions. But I would limit myself now to one point that connects to what has been just said, and is the following: is the fact that in the new DSM directive, in fact, there are interesting exceptions, and the out-of-commerce, Article 8 out-of-commerce is certainly one of these, which are quite surprisingly broad and surprisingly, in a way, revolutionary, okay, in copyright. But the limit is that this exception and licensing mechanism is only limited to certain categories of users, namely cultural institutions, and the same also applies to the text and data mining exception. So, which sort of limits probably the freedom of individual users, like in the examples that were made before of video games and the abandonment of video games. So my question is for Svetlana. I appreciated very much your presentation on Article 8. Of whether do you consider this to be a limit? How significant is this limitation to cultural institutions and not to individuals to make use of or out-of-commerce works?
You can hear me? Oh. Well, thank you for your question. I think that the concept of exception and limitation is very important, and especially for not just individual users, but also cultural heritage institutions. But I think that could be the way for the future. Maybe in not just in out-of-commerce works, but for out-of-commerce works, but for digitization at all, maybe that could be the way. That's just my thinking, but I come from a country, I'm not from European Union, I come from country, my country doesn't have, our copyright law is not yet harmonized with the EU laws, and that's something we don't have in Bosnia and Herzegovina, but in the future I think that we should generally in copyright, maybe the future is not on insisting on that exclusivity. It's important in digital environment. We cannot enforce, at least in my country, we have big problems with enforcing intellectual property rights at all and enforcing copyright, especially in digital environment. And it's very difficult. I think that also that we have intermediaries. Their roles is also they are also very important for that enforcing of rights. We should maybe the future should be different, and we should insist on maybe not. We should not insist on exclusivity of that right, but maybe for any kind of exception or limitation, or if we cannot enforce right in a proper way, that can be signal to make some changes, and that's something that I wanted to say about and out of commerce works, and also all kind of works, and also digitization, process of digitization. Maybe we should not insist on that exclusivity in the future.
Yeah, thanks, Svetlana. And by the way, well, the limits that Maurizio was mentioning related to the out-of-commerce works are the same that we have for the orphan works directive, because you know the limits are just the beneficiaries are just the cultural heritage institutions. But as we said before, the cultural heritage is much broader than that. And my question that I wanted to ask you before was exactly about the Bosnia situation, or the Bosnia approach to that. There's a question from you too for Bodan and Francisco, which refers to your research related to the presentation that you just had. So the question is there anything already written and published? And if so, could you kindly share it? And we are all takers, I think, even in Polish. It's fine.
All right, so there is a book in Polish, unfortunately, only, but I'm working on something in English, so hopefully when I get my together and finish it, it's going to be available sooner than later.
So there's a book. It's an American book, so it's mostly centered around the MCA, but it has a small European chapter on that. And honestly, you can also read my paper on this, which is coming soon, and that's a good resource, I'd say, for my own presentation. That's what it's based on. Other than that, there's one old paper from 2012, so it's not DSM updated yet, but it already made some very accurate predictions, honestly. So those are the things that I could recommend as resources.
Okay, so it's 12:31. Because we were so passionate about the discussion that we couldn't leave it punctual, but I think that we managed the time very appropriately. I personally learned that so much, so I do not regret at all to have taken a train, a plane, a bus, a train to come here. I really appreciated any single presentation. Thanks again, Peter, for this amazing organization. I think that we are now free. Thanks also to the people online that asked questions, and a big thanks to Maurizio as well. We now have time for lunch. We're going to resume at 1:30 here for the training. If you haven't read the documents that Peter shared, please do that now. Thank you.
Good morning, everyone. My name is Qian Yu. I'm from China. First of all, I would like to thank Professor Mezi Peter and the Szeged University School of Law for inviting us to discuss such interesting and important topics. My topic is about consumer protection in China's e-commerce platform. Let me share my screen. Consumer protection in China's e-commerce platform is a problem. Let's see the charts here. China's e-commerce platform market is quite unique because we can see from the chart in the right that China's retail sales in e-commerce platform is more than half in the total retail sales in China. And from the chart in the left, we can see that the amount of e-commerce sales in China is quite large. It's about 3,000 billion US dollars. It's several times larger than that of the US and the EU, and it's almost half of the world's e-commerce sales in 2021. This large number of sales also leads to the large numbers of sales in infringing product. We can see from the pictures that fake shoes, fake bags, and fake luxurious products are sold in China's e-commerce platforms. For this phenomenon, China adopts e-commerce law in 2018. Article 42 provides that an IPR holder can inform the e-commerce platform to remove the infringing product, to block and disable the transaction if comprehensive evidence is provided. This is the rule of notice and delete in China, which is called notice takedown in the EU and worldwide. The application of the notice delete rule is quite efficient because it includes two types of procedure. The first type of a procedure is that genuine product dealer provides notice to e-commerce platform, and the e-commerce platform review this notice and delete the infringing product. The second type of a procedure starts from also a notice from genuine product dealer. E-commerce platform review the notice and delete the product, and also send notice to the suspicious product dealer about their decision. If the infringing product is not infringing. The suspicious infringing product dealer can send a statement of non-infringement to the e-commerce platform. After review, the e-commerce platform will restore the product or restore the link in the e-commerce platform. These procedures provides many efficiencies. The first is that the solutions for the infringement disputes via e-commerce platform is faster and more efficient than that made in courts and IP enforcement agencies, because the whole procedure of the notice delete rule takes at most 2 weeks. But that in the courts and the IP enforcement agencies takes at least 2 weeks, at least 2 months. So we can see it's quite faster. The second efficiency is the rule provides e-commerce platform with safe harbor. Because if e-commerce platform do not apply the notice delete rule, the genuine product dealer will claim for compensation from both e-commerce platform and infringing product dealer. So this notice delete rule exempt e-commerce platform from being claimed for compensation. And as a result, e-commerce platform become an IP law enforcement body other than courts and IP enforcement agency. And the facts shows that IP law enforcement within e-commerce platform is quite leads to 2 different results. The first result is that IP infringement notice declined and is still declining. The bad result is that the bad faith notice is increasing. This is because there are inherent defects associated with notice delete rule. The first defect is that the notice delete rule and the e-commerce platform do not distinct from fair use and infringing. The second defect is that the notice delete rule does not prevent repeated notification. This leads to the notice come to the e-commerce platform again and again. The third defect is that the procedure of a notice delete rule can be easily abused because the notice delete rule takes several steps, and each of the steps can be abused. The last defect is that the notice delete rule provide immediate impact on competitors because and either of the types of procedures, the suspicious infringing product will be removed from the e-commerce platform. So competitors are immediately prevented from competing with genuine product. So all these 4 defects leads to bad faith notice. Let's see a very famous case. The case happens between Bayer and a Chinese people. Bear registered 2 copyrighted work. We can see the pictures. And then King Li registered these 2 trademarks. This part, you can see that is part of the copyrighted work. After registering the trademarks, Qin Li sent notice to e-commerce platform to remove Bear's products. And finally, Bear's products were removed. Bear then filed litigations with Qin Li in the court and finally won the case. This case indicates that the application of the notice delete rule must be modified because the bad faith notice dilemma is becoming difficult. The first solution is that the current situation in Chinese e-commerce platform is that the e-commerce platform is lack of technology and information to identify the infringing product. And IPR enforcement administrative agencies have the necessary information and high technology, but there are no cooperation between the 2 bodies. So there's a necessity for them to cooperate to promote the efficient identification of an infringing product. The second solution is that established notice delete rule covers the function of mediation and infringement litigation. This has led to the notice delete rule much burdensome. So the solution is that the boundaries for notice delete rule, mediation, and litigation should be set clear, and the scope of a notice delete rule must be narrow, and the application of notice delete rule should be focused on a special target, so it can make the notice delete rule is quite efficient. It's more efficient. So this is my presentation. Thank you for your attention.